More than ever before, we must not forget what we have had to overcome throughout history. We must not forget the valuable lessons we have learned. We must not forget why we forged our alliance. What made us stronger? What we have learned. That alliances are made by people. We need to remember that appeasement does not create peace. For peace, we need to be ready to stand together. Democracy is delicate. It needs to be actively protected and fostered. Only then can justice prevail, and the European community can prosper. In challenging times, the Czech historic experience brings a unique perspective that is so important for our focus going forward. In 2022, the Czech Republic holds the presidency of the European Union. Now is the time to write the future of Europe. Let's find our path together.
Ladies and gentlemen, let me welcome you all to this wonderful place, a ball game hall of the Prague Castle, at the occasion of the European Competition Day 2022. The jingle that just we had a chance to see emphasized on how important it is to be together, how important it is to stay together, work together, because together we are stronger. And that is exactly what we will do here today. Actually, this building used to be a place for sports. And as we all know, in the sport, a teamwork plays a very, very important role on the way to success. Also, the priorities of the Czech presidency to the EU aim to be stronger together while focusing on the Ukraine post-war recovery, energy security, strengthening Europe's defense capabilities, strategic resilience of the European economy, and resilience of democratic institutions. Part of it is the European competition agenda, even more important nowadays when we need to protect the consumers, the people, but at the same time keep the competition going. That's very important, and that's exactly what the European agenda is about. And we'll have three specific panels, three specific topics today to focus on, but we'll get to know more about it from our host, the chairman of the Office for the Protection of Competition of the Czech Republic, Petr Mlsna, whom I would like to invite to the stage and asking him for his opening speech.
Thank you. Ladies and gentlemen, dear guests, after 13 years, the Czech Republic holds the presidency of the Council of the European Union. And after 13 years, the Office for the Protection of Competition organizes the European Competition Day. This time not like in 2009 in Brno, but in Prague, in very historical center of the Czech state at Prague Castle. Allow me to give you all a warm welcome. In particular, I welcome the honored guest who will be opening the conference with me. The Executive Vice President of the European Commission, Margaret Vestager, and the representatives of the Czech government, the Minister of Justice, Pavel Blažek. It is especially a great honor for me to have representatives to the Ukrainian Competition Authority present, and I would like to express our support for Ukraine in these hard times. I also thank all members of the expert panels who are ready to share their thoughts with us. Last but not least, I welcome all those of whom competition law is a profession, whether they practice it within state administration, in academia, or in private sector. We are now in an era where the volume of economic interaction is constantly growing. Business models and markets are more complex, new industries are emerging, and business is moving more and more into the online world. The market power of well-established players, especially digital platforms, is growing, and data is an essential resource for business success. However, at the same time, we are also in a time not only affected by positive technological progress and development, but also a time heavily affected by the COVID pandemic, energy crisis, the ongoing unprecedented Russian aggression in Ukraine. Consequences of these events on the European economy are enormous. Many markets are experiencing dramatic changes or even failures. Prices are fixing, inflation is out of control, and European consumers are calling for regulation, prices cap, and social aid. In particular, this is necessary in the area of energy prices, which have skyrocketed, mainly due to dependence on Russian gas. Governments across Europe, and of course, the European Commission, are therefore looking for solutions to mitigate and resolve this crisis. In particular, the common European state aid rules are proving to be crucial in the short-term perspective, allowing for rapid and targeted aid to the most affected entities. We are therefore pleased that the European Commission has reacted quickly by adopting the temporary crisis framework, which sets out clear guidelines on which state aid will be considered compatible with the internal market when dealing with high energy prices. Important projects of common economic interest are one of the themes of this conference. The concept of these projects is one of the European Union's responses to the global competition in key industries of today, such as electromobility, chip manufacturing, the development of 5G networks. This project should also contribute to addressing the consequences of this crisis. Nevertheless, the conceptual solution for European energy independence is the planned shift to sustainability as part of the long-term Green Deal strategy. This objective should be fully supported and promoted. However, the problem is, unlike direct aid, this objective takes time. Therefore, in a situation which is unprecedented and which requires a quick solution, it is advisable to consider, for example, the postponing of such a transition and the longer use of fossil fuels. It is absolutely necessary to provide countries, businesses, above all European citizens, with their basic needs, which certainly include energy. Of course, eventual postponing must be limited only for the time necessary to overcome current crisis. In no way I am suggesting that we should abandon the path to sustainability. But in an unprecedented situation, which no one could predict it when formulating existing policies, we need to consider crisis solutions and to respond to the new reality. I fully support the research for and incentives towards alternative resources in the energy sector. For example, the need to invest in research or development. This could bring new possibilities, whether in the area of direct generation or efficient energy storage. What should be the main role of the competition authority in such circumstances? Clearly, it is not shaping sustainability policy. Competition authority is primarily a guardian of functioning competitive markets. Therefore, the main role of the competition authorities is protecting competition against anti-competitive actions of undertakings. However, it is equally important for the competition authority, especially at the time of strong calls for all sorts of regulation, to assist other public authorities in their regulatory efforts and to seek solutions so that potential regulation distorts competition as little as possible. In order to be able to perform their primary function responsibly and effectively, competition authority needs to have sufficient capacity, expertise, technical equipment, but also adequate legal instruments. The minimum standard in this respect was brought about by the ICN Directive Plus. This legal act, unfortunately, has not been transposed in the Czech Republic yet, but a proposal has already been submitted, and I firmly believe that despite the difficult situation, it will be approved in the nearest future. Our proposals also contain some institutes beyond the scope of the directive. This includes, for example, the possibility of using leniency for vertical agreements, more effective securing of complainant identity, or the more effective banning on participation in public procurement. After all, bid rigging and the fight against cartels in public procurement is one of the office's long-standing priorities. I can say that we are succeeding in this fight, whereas we are also taking advantage of the unique synergies of also being a body which reviews the public procurement awarding process. There are many novelties in the area of competition protection that need to be explained and communicated to businesses as much as possible, and they need to be encouraged to comply with them. This necessary transparency is sought by the Czech Competition Authority. We are doing our best to promote prevention and education, to communicate and cooperate. And our partners are universities, state administration bodies, chambers, and associations of undertakings, as well as political representation. When I mentioned prevention, we have changed our policy and decided to take robust compliance programs into account as a mitigating factor in the calculation of fines. I should note that this is not a blank check for a discount. We are only prepared to consider fine reductions in cases where the undertaking in question has successfully applied for leniency or settled with the office. This approach should be encouraged undertakings to invest in prevention, while making institutes of leniency and settlement even more attractive. As a new approach to motivate faster and more efficient investigation where the leniency program cannot be applied, we have introduced the possibility of voluntarily submitting self-incriminating evidence with added value like in leniency of anti-competitive conduct in the area of vertical agreements or abuse of dominant position. I have to say that particularly in the area of vertical agreements, there is considerable interest in using this type of cooperation with the office, and we expect the first cases of this quasi-leniency in the near future. Competition authorities now themselves are in a difficult period where they have to carefully assess which policy direction to pursue, how to use their limited resources, what type of cases to investigate, which markets to investigate, and which tools to use. I believe that current situation requires us to look first and foremost at whether the negative consequences are most apparent, and when the very structure of the market allows for potential collusion or abuse of dominant position. It is in this area where undertakings may be tempted to compensate for increased costs by collusive behavior to disadvantage of consumers. In this respect, I strongly caution that any finding of distortion of competition in this way in markets for essential goods will be pursued by the office in the strictest possible manner. Ladies and gentlemen, I hope that today's conference, the presentations and discussions you will see or you will hear will inspire you, and that together we will contribute to the future direction of competition policy in the European Union. Thank you very much for your attention.
Petr Mlsna, the chairman of the Czech Competition Authority, gave us a very detailed explanation on what should be discussed here today, and not only here and today. It is also a great pleasure to welcome here, already mentioned, the European Commission's Executive Vice President for a Europe Fit for the Digital Age and Competition, Mrs. Margaret Vestager, and ask her for her opening speech.
Thank you very much. And thank you also for the opening. I think it is very important that we remind ourselves that appeasement doesn't lead to peace, and that these are difficult times for everyone, so that our community, our robustness, our resilience is key to come out stronger on the other side. We meet here in the shadows of war, so close to this beautiful city. I wish it was not so, but obviously we cannot choose the times that we live in. What we can choose is how we react to the things that happens around us. I've been doing quite a bit of traveling lately, from Dublin to Copenhagen, from Italy here to Prague. And what strikes me is a sense of solidarity, of resolve, of courage all over Europe. And it gives me hope, but also confidence that we can rise to the challenge. And when it comes to the other side of this extremely critical situation, that we will be more united and stronger than even in the most recent past. As competition law enforcers, we do not always take the front page of Europe's newspapers. Most of the time, the work we do to keep markets running, well, that goes kind of unnoticed, a bit like sort of air traffic controllers. I don't think passengers in a plane give them a second thought. Of course it works. Nevertheless, we have a very important role to play at all times, whether that will be for the cost of energy or cost of living issues, the damages caused by Putin's war of aggression, or with the longer-term strategic challenges of the digital and the green transition. Because the proper functioning of our markets is precisely what will allow us to adjust to change in a way that minimizes the cost and maximizes the benefits. And crisis obviously can cause a mismatch between supply and demand. But when markets work efficiently, well, then price signals will direct investment in a way that can bring a market into balance. Thanks to competition, markets work efficiently, and that gives companies an incentive to innovate. And innovation can, as just one example, turn green transition from a cost in the economy into a series of business opportunities that makes us all better off. And this will allow us to decouple our economy from insecure energy suppliers, creating more long-term resilience, and give Europe a stronger hand to play on the global stage. And this is why I would stress a simple point in the current debate. Competitive markets is not a luxury to be enjoyed on a calm, sunny day. They are necessity. Because all the more so when the weather gets stormy. And the exceptions we may choose to make, well, they must be well justified and contained within the flexibility arrangements of our competition rules. So protecting competition is about efficiency, but not only. It's a question of fairness. And fairness is a concept I've been really happy to see have gained more and more traction in the competition policy community in recent years and weeks, and rightly so. We don't often think about our works in terms of social policy, but in fact, there are aspects of that as well. By keeping prices close to costs, this generates consumer surplus, benefiting obviously low-income households the most. And when you look at the sectors where your cases are taken, you can see that in antitrust, many cases, they come from the sector in consumer sectors where high margins can have immediate impact on households. We are on the side of people. That is only part of the story. We also know that keeping markets open to small players, to new entrants, that benefit female entrepreneurs and entrepreneurs with a migrant background. And in this way, markets also becomes a tool of integration, of social change and progress against a historical background where things were not always so that everyone had a fair chance of making it. The concept of fairness as applied to competition policy is well recognized, both in the European treaties and in the EU case law. And with the full transposition of the ECN directive, it will also become a uniform guiding principle informing the work of national competition authorities across our union. Fairness is what motivated us to take a closer look of the working conditions of the solo self-employed. So last month, we issued new guidance to provide legal certainty for when competition policy will not stand in the way of their effort to engage in collective bargaining. And fairness is also what we considered in our very first design of the temporary crisis framework, avoiding subsidy raises while ensuring that those who are most affected by the crisis can receive the support they need. And fairness is also at the heart of the Digital Markets Act, which has the aim to ensure fair conditions for all businesses. And this is also why we are hosting a conference in Brussels on the 27th of this month on making markets work for people, in which leading academics, enforcers, practitioners can come together to explore how we can make that even more true. On one thing, however, we should be cautious. There is at least a risk of viewing efficiency and fairness as opposing objectives for competition law enforcers. And that leads us to see a fundamental trade-off in our work between two important policy goals. But I think it would be a mistake to overplay this idea, because in a social market system, the two goals are more often than not completely aligned. It is true that competition by its very nature includes winners and losers. But as long as a social market economy is working properly, the efficiency gains that comes from this process can be fairly and justly shared across all stakeholders. There's no contradiction between defending efficient markets and promoting good social policy. Of course, it's possible to find examples where efficient market outcomes result in apparent unfairness. Obviously, these examples exist. But competition policy is not the only tool that we have to ensure a fair outcome. And often, in many times, it's not even the best tool suited for this policy goal. In the EU's social market economy, we provide and we promote universal healthcare, minimum income to ensure that everyone can have a somewhat decent standard of living, as well as consumer protection laws, as product safety standards that obliges companies to do the right thing, regardless of the structure of the market where they operate. In a sense, therefore, whenever a trade-off between efficiency and fairness begins to show, that may signal a need to put more social into the social market economy using our full toolkit. Obviously, the devil is in the detail. Enforcement that is both fair and efficient depends on applying the right theories of harm in the cases that we run. For example, in the Illumina Grail case, the ultimate objective of our decision to block the deal was to have an efficient market for cancer detection. Taking action at this very crucial stage of product development means fairness for tomorrow's citizens, giving them a fair chance to benefit from the widest possible choice of tests to detect these diseases earlier on. And today we have, I think, another good example. We have just sent a statement of objection to Teva for suspected antitrust breaches in the market for multiple sclerosis medicine. And here we employ two theories of harm, of which the first one is novel. And this relates to our concern about how Teva may have gamed the patent system to artificially prolong or extend market exclusivity and thereby delay the entry of competing medicines. Those medicines, in turn, would have led to efficient price competition. If confirmed, this implies that the national health systems has for years been overpaying for this multiple sclerosis treatment. And of course, that is unfair for patients suffering from this chronic disease. The second theory of harm concerns a systemic disparagement campaign, because we have indications of this, that Teva has led such a campaign against competing multiple sclerosis medicine by misleading doctors and health bodies about its safety and about its efficacy. And this is a theory of harm that unfortunately resonates in a world where misinformation is endemic. Ultimately, both pursue fairness objectives. And I would encourage any colleague in the enforcement community to be willing to explore the boundaries and not to shy away from novel theories of harm where they are relevant and where we have evidence to support them. Because by finding and exploring the boundaries, we have more scope to deliver the win-win outcomes that result in concrete benefits for consumers, for households, while also protecting the efficient markets that makes us stronger in the long run. With all the turbulence, with the digital transition continuing, and with new technologies playing a still bigger role in market dynamics, pursuing these goals, which means that we have to stay creative and open-minded to see the abuses that is at the heart of our mission to look for. It won't be easy, but the sense of common purpose that I feel around Europe is also present in our work as competition law enforcers. With the ECN Plus and with the new application of Article 22 of the merger regulation, the Commission and the national competition authorities are more a team than ever before. And when you look around the room, I think you will agree with me that this is a good thing indeed. Because even faced with deep uncertainty, even under the shadow of war, every case we take, every decision that we issue improves the competition ecosystem, making our markets stronger, make them more resilient. And that, of course, makes them better in serving citizens in their role as consumers. And that, in turn, brings us closer to exiting these times of extreme crisis to be what we are, a strong union and a fair union. Thank you very much.
The Executive Vice President of the European Commission, Mrs. Margaret Vestager. I think that we've heard she stands for the most powerful regulator in the world, as we heard about the current topic. And let's move further. As the state aid and competition agenda is very, very important, especially these days, as we've heard many times, also the Czech Minister of Justice took his part in looking for a solution in the times of energy crisis. And now I'm pleased to welcome here the Minister of Justice of the Czech Republic, Mr. Pavel Blažek, and ask him for a few words to open the European Competition Day.
Dear Executive Vice President of the European Commission, dear Margaret, dear President of the Czech Office for the Protection of Competition, dear Petr, dear ladies, dear gentlemen, I am very honored to launch your European Competition Day in such a beautiful place as Míčovna, historical ballroom of the Prague Castle. At the same time, let me apologize to Czech Prime Minister Petr Fiala, who has asked me to participate on his behalf. As Minister of the Czech government, I am fully aware of the key role of protecting free competition, and I am also aware of the importance of DG competition in the hierarchy of the European Commission. This is why I am honored to present my short speech in front of the boss of this successful DG, Margaret Vestager. She's not here, but doesn't matter. The success of the Czech presidency of the EU in the difficult times is a key achievement for the entire Czech government. Unfortunately, the Russian invasion of Ukraine and its consequences have overshadowed other topics. Even so, and mainly because of that, I am very glad that we can meet here in Prague for European Competition Day. I warmly welcome you on behalf of the government of the Czech Republic, and I wish you fruitful discussions and successful conference. Thank you for your attention.
The Minister of Justice of the Czech Republic, Mr. Pavel Blažek, thank you. We start with a very current topic. As in Europe, we are all aiming for a more greener and more digital future. We also need to look at the challenges it brings for the competition authorities, especially during these uneasy days and times. What times we are going through, we've already heard through the keynotes. So just to mention war in Ukraine, energy crisis and huge inflation being just a little part of it. We will hear now more in detail 3 important topics in the first panel. The first being how competition enforcement could go hand in hand with sustainability goals in the framework of the Green Deal. The second is about effectivity of tools that competition authorities use for their investigations. And the third being about challenges and opportunities for competition authorities in the online world and the phenomena of big data and machine learning and so. Let me welcome here the panelists of the first panel, Kamil Nejasklep, Vice Chairman of the Czech Competition Authority, who is engaged in modernization of legal instruments for detection of cartel already since his studies, and now is active also within the European as well as international competition network, and who will moderate this panel. I would also like to welcome Olivier Kirsan, Director General of the Directorate General for Competition. He joined the Commission 30 years ago, since when he has alternated between the private offices of commissioners and of the DG Competition. We also have Margarita Matos Rosa, President of the Portuguese Competition Authority and Vice Chair of the International Antitrust Agencies Network, ICN. She has experience from the private, mostly financial sector as well. Let me welcome Frédéric Geny, Chairman of the OECD Competition Committee and co-director of the European Center for Law and Economics of ESSEC Business School, previously worked, e.g. for the French Competition Authority or as a president of the WTO Working Group on Trade and Competition. And last but not least, Thibaut Schreppel. Okay, good, thank you. An associate professor of law at the Free University of Amsterdam, where he co-directs the Amsterdam Law and Technology Institute and a faculty affiliate at Stafford University Codex Center, where he has created the Competitional Antitrust Project, which brings together over 60 antitrust agencies. Now they'll have more than 1 hour for their discussion, but I hope that you will also take your part. As we have prepared the direct connection from your side to this side, you may use your IoTs, the clever things we wear like mobiles, use application slido.com and get to the European Competition Conference in Prague. We should have the QR codes everywhere so that you can scan it and get inside. They were on the tables. I don't know if we have some to get on the screen so that we could show. If not, you just find European Competition Day 2022 and you may send a question. If not, I'll just arrange for you to have a QR code so that you can get to the application and ask any one of the panelists. I would just ask you to direct the questions to one of them so that we know whom would you like to hear as the one to answer your question. But now I give the stage to Kamil Nejasklep as the moderator of this panel.
Hello, ladies and gentlemen. I can't start with anything else than saying it's an honor, a great honor for me to be here as a part of this wonderful Competition Day 2022. It's also a great honor having here such a distinguished speakers and experts of competition law and economics here at this panel. I'm very much looking forward to our discussions, and I would like to immediately start with the first topic, which is nothing else than the problematic of competition law and sustainability goals. The key role of competition authorities is, not surprisingly, protection of competition. Why? Not for the beauty of competition itself, and I believe the competition is a really beautiful thing, but for the benefits of consumers. Competition drives prices down, output up, brings more choice, innovation, quality. It increases consumers' welfare. In the recent ECJ judgment, Servizio Elettrico Nazionale, sorry for my Italian, and others, the court explicitly said, and I quote, "Well-being of both intermediary and final consumers must be regarded as the ultimate objective warranting the intervention of competition law." This clearly shows that European courts regards consumers' welfare as a goal towards which the competition protection aims. If sustainability is a part of the consumer's welfare standard, then the question, of course, is how to assess it against the others values that are incorporated in the consumer's welfare. More traditional parts, and by those I mean already mentioned prices, output, choice and innovation. When, for example, price goes up because of a sustainability agreement, but on the other hand, the solution of this agreement is really sustainable. In such situations, we just have to do a balancing. In this regard, one of our panelists, Professor Schreppel, wrote with regard to the Dutch guidelines regarding collaboration between farmers on Twitter that we need to address trade-offs. And he ended his tweet by saying, "We, law professors, enforcers, practitioner lawyers, can afford higher prices, and we are those who are drafting rules. I wish those who cannot afford higher prices were also involved in drafting." Therefore, I think that when any competition authority thinks about such a trade-off, it should do it with very, very carefully, and should also be open and explain its thinking in this area. I also would like to say that if in a particular market consumers are, I call it green sensitive, and by it I mean willing to pay more for sustainable products and services, I really think that in such market the competition should be the best way how to achieve sustainability. So I would be quite reluctant in such markets to be very open to sustainable agreements that as other effect, for example, hampers the other values of a consumer's welfare standard. And also I think that the test if consumers are, as I mentioned, green sensitive in a particular market should be incorporated in every assessment when we are thinking about sustainability agreements. In all cases, the Czech NCA is prepared to proceed very strictly against any infringement of competition law covered behind so-called greenwashing, or directly slowing transition to more green and sustainable solutions. Last remark before I pass the floor to other panelists. Till now I spoke almost exclusively about agreements. But what about Article 102 TFEU and objective justification? Could dominant undertaking, for example, squeeze less green undertakings from the market? Would it be an abuse? Or what about green mergers and efficiency defense? Given that sustainability and environmental protection are considered as a part of the consumer's welfare standard, I think this standard is valid also for the other areas of competition enforcement. Then I think sooner or later we will have to tackle these issues as well in these areas. Thank you, and by saying this, I'm passing the floor to Olivier.
Thank you, Kamil. Maybe a couple of remarks. Well, first of all, it's a bit difficult to talk about competition policy in general. I carve out immediately state aids, because in state aids, there's no tension. I mean, we have decided with the new guidelines for state aid to energy, environment, and climate, basically to make it easier to subsidize everything that contributes to the transition to a low-carbon economy, and to make it a lot more complicated, if not impossible, to subsidize broad investment. So here, there is no real issue. We are in the process of even simplifying the rules in order to deploy more quickly in the framework of the temporary crisis framework, because of course the problem has become all of a sudden more acute. But I would say this is an area in which there is a relative alignment of the various elements. It's a bit different in traditional antitrust and merger control. To understand that, it's necessary to take a couple of steps back. What we did in 2003, when we adopted Regulation 1, was actually to reduce the scope for 101 paragraph 1 to essentially what is the efficiency defense. Before that, under Regulation 17, the case law and the decision practice of the Commission was that 101 paragraph 1, at that time 85 paragraph 1, was basically about microeconomic restriction to competition, and the paragraph 3 was about a broad range of macroeconomic benefits. And in some of our member states, this is still the way the test is applied for the national law. This is the case in France in particular, where efficiencies in the field of employment are openly taken into account. What we did in 2003 was to have the same standard, so shrinking massively the way we interpret Article 101, paragraph 3, so that it is identical to the way we assess efficiencies in mergers. And you're right, Kamel, therefore introducing the same standard for objective justifications in Article 102. So it's beautiful because it's perfectly aligned. And the question that we have in front of us now is basically, should we keep on with this alignment, or are there reasons to consider differently the test for objective justifications, the test for efficiency defense in mergers, and the test for 101 paragraph 3. And it's a complicated question, not only because of this alignment or disalignment cross-instrument, but also because whatever you decide, you will not decide it only for environmental efficiencies. Because there is no way you can say, I have this interpretation for environmental efficiencies, but not for other type of efficiencies. So if you open the door, you open the door. You cannot say, well, it goes only for the environment. And I think Margrethe was quite clear. There are a number of other considerations in which increasingly enforcement of competition rules plays together with a number of other standards of law. Privacy protection, for example. She mentioned disinformation. And of course, green efficiencies. So increasingly, we're faced with the problem where our core mandate is to protect competition, but you can do that in different ways. And the whole challenge, in a way, is not so much to be helpful for other objectives or other standards of law, but mainly not to stand in the way. It would be senseless, in the name of protection of competition, to impose decisions that are contrary to our decarbonation objectives or that runs against the protection of privacy, etc. That would actually even not be allowed by the court, because the court forces the Commission to be consistent when implementing the various standards of law. So that's the challenge we're confronted with. And actually, the new draft guidelines on horizontal restrictions open the door for at least slight disalignment between efficiencies in mergers objective justification in 102 and the interpretation of 101 paragraph 3. That is, of course, possible because it's not a question of law, it's a question of policy. And the question is, to what extent do you allow this alignment? And the focus of the discussion is on the concept of full compensation. And I think this is important in that respect to mention that we do not have a proper consumer welfare standard in the EU. What the treaty protects is allocative efficiencies of markets, but we don't have, unlike the Americans, for example, a restitution standard, because, of course, I mean, protection of consumer welfare and fairness is important, but it's not really the main compass of the implementation of the law, and that gives us a bit of leeway in the interpretation of Article 101, paragraph 3. So this focus on full compensation of in-market, so should those consumers that have suffered the detrimental impact of the anti-competitive or would-be anti-competitive agreement, are they the exact same ones that should be compensated, and should they be fully compensated? In other words, can you take into account out-of-market compensations? That's a point in which arguably the draft guidelines are not fully clear, and I will reveal to you that it is intentional, because we're at the very beginning of that journey. So to the question that is asked to the panel, is it sufficiently accepted? I think it is, but how we will progress, how we will guarantee that we don't end up clearing what is essentially greenwashing of anti-competitive agreement remains very important. And that's why we want to be cautious. And I will conclude my remarks on this point by saying that I'm very happy to consider in confidentiality and in confidence draft agreements by firms that would have anti-competitive effect, be absolutely indispensable to reach environmental benefits, and that these environmental benefits are tangible, measurable. If this animal exists, but I've never seen any, I'm very happy to see and put it in the debate within the ECN, because it would be good that we have a broad agreement on the way to travel so that we don't have forum shopping within Europe, and have a discussion whether we should or not exempt this particular agreement. But my sense is that most of the agreements that are beneficial for environment are relatively unlikely to produce large anti-competitive effects. Or if they do, there's probably a less anti-competitive way to reach the same effects. And that might be the reason why, although Mrs. Vestager signaled 2 years ago a willingness to consider this type of agreements, we have, at the moment I speak, not seen any, and the companies didn't come to us with any of this type of agreement. So maybe it's not such a large problem in real life.
Thank you, Camille. Thank you, Camille, for the opportunity to come here and celebrate competition policy with the Czech Competition Authority. And I would like to congratulate President Petr Myslne and as well as the whole of the Czech Competition Authority for doing just this, to celebrate competition policy in the EU and give us an opportunity to not take it for granted, I would say. It's something we very much across the European Union work on a daily basis to maintain and to continue to enforce. Having said this, I will go a step back, or take a step back from what Olivier has just been saying. He stepped right into the heart of the current debate. And I will start by maybe saying what we have achieved altogether over the past couple of years on this topic of competition and sustainability. And I would say that there was consensus, of course, that we as competition authorities should also do our utmost in order to integrate the Green Deal goals into what we did. We did not shy away from that discussion. We first, of course, acknowledged that there was regulation, that it was probably well suited to achieve some of those goals, but we also admitted that state aid was probably one of the best candidates to do just that, and that was what was done. Now, moving a little bit further on this debate, we became a bit more specific, and it became clear that more often than not, competition and sustainability can go hand in hand, and this is exactly what you said just now. And this is because competition is clearly a driver of green innovation. And this is because currently, at least, the high consumer demand for green products is driving this innovation. Firms have incentives to innovate in that direction. Moreover, green innovation may also decrease costs for firms, and we see this very clearly on a day-by-day basis, especially now that the cost of energy is very high. Less energy consumption can drive greener production methods. Firms may have incentives also to reduce waste, to recycle, and this all goes in the direction of the Green Deal. Now, then there is the case of agreements that firms can try to sign or to have, and we need to be specific and somewhat critical here, because there may be cases, of course, where firms may want to reduce, for example, single-use plastics or reduce the number of printed materials, and that's very good, but can they do all this alone without entering into an agreement with other firms? And if so, if they can do this, if they need to enter an agreement, if they cannot do this alone, can they be neutral from a competition point of view? The good news is that we found over this past couple of years debate that there is flexibility embedded in competition law. And this gives room for such cases that I just mentioned. Competition law is aimed at combating anti-competitive agreements, not just agreements per se. So again, there is room, there is flexibility, but we need to be selective. Let me mention again that these new draft guidelines are a good effort to accommodate sustainability concerns without compromising the mandate of competition enforcers. And maybe I should finish here just by saying that we should not forget that there is a risk of greenwashing, and it is our job to, as enforcers, to avoid it. And this is because such illegal agreements not only harm consumers, but they also prevent more green investment to occur. And this, I think, would not be a good outcome. This would actually be a poor outcome for any one of us. And I'll stop here.
Thank you very much. First of all, at a personal level, I want to say that I'm extremely happy to be here and in this debate on sustainability, because having been trained as an economist and the classical Pareto framework, if there are huge benefits to be had from something, and if these huge benefits, wherever they take place, can compensate the losses that are imposed, it's obviously Pareto optimal to try to move in that direction. So there is some recognition there of the Pareto principle. The second reason I'm very happy to be here is that I want to point out that not only has the EU taken a massive initiative with the new horizontal guidelines, but the Dutch Competition Authority and the Greek Competition Authority, both separately and together, have hugely contributed to raise those issues. And it's nice to see the way in which member states have pushed the Commission in some way to take on board a really important social problem. The third reason why I'm very happy is that it makes me feel much younger. When I read the new horizontal guidelines, I feel like I'm 20 years younger when I joined the WTO, and where I was told that the principle of the WTO was constructive ambiguity. And it seems to me that the new horizontal guidelines on this issue of sustainability is a fairly good example of that. I will mention 2 paragraphs just to give you an idea, because I think they are crucial to the discussion. One of those paragraphs states, the benefits deriving from the agreement must outweigh the harm caused by the same agreement, so that the overall effect on consumers in the relevant market is at least neutral. Okay? The second paragraph says, where consumers in the relevant market substantially overlap with or are part of the beneficiaries outside the relevant market, the collective benefit to the consumers in the relevant market occurring outside of that market can be taken into account if they are significant enough to compensate consumers in the relevant market. The interpretation of those 2 paragraphs, read one after the other, is not obvious. There seems to be a tension, which was mentioned earlier on by Olivier Garçon, between 2 ideas. One of them, there should be compensation in market. The other one, there should be a bit of an opening and allowing compensation to include benefits that would come outside of the market. What are those benefits? I think that there the guideline is very useful by saying there are 3 types of benefit: the individual use value benefits, the individual non-use benefits, the benefit from knowing that the world is getting better, and the collective benefit, which are the result of the externalities. So let me very briefly say that I have 2 feelings about the new horizontal guidelines. One of them is that there is the ambiguity, which I have mentioned, and this will have to be worked out. The second one is that to know really what is going to be the impact of this, of course, one has to ask what is going to be the definition of relevant markets. We know that this is a complicated issue. What is going to be the concept of substantial overlap? What is going to be the concept of non-market benefit being significant enough? So what is going to be the threshold there? So we do have quite a bit of work to do in the interpretation of this text. But my last point is to say one thing which concerns me. It's clear that at least if we think of sustainability in the climate dimension, because there are other dimensions of sustainability which I'm not going to talk about now, but it's clear that the benefits from any agreement, if there was an agreement which might be anti-competitive but also would have pro-climate benefits, that those benefits are going to be coming over time, and they're going to be cumulative. So therefore, assessing the importance of those benefits is very much going to depend on what is the time frame of the analysis. And the longer the time frame of the analysis, presumably the higher the benefits will be. Now, we as competition authorities have tendency to have a very short-term framework when we look at anti-competitive practices. It's enough that there is immediately an increase in price so that the 101 would apply. Shouldn't we have a reflection on what is the proper time perspective when we look at those agreements, which may be anti-competitive? And I agree with Margarita, there are not so many cases where this is going to happen, but the guideline is done for those cases. So shouldn't we have a better concept of what is the relevant time frame for the analysis? Are we talking about long-term? Are we talking about short-term for competition? Long-term for efficiency? Are we talking, exactly. And I think that this is a discussion that we should have had already before, but it is made even more important when one thinks about sustainability. So that's just what I wanted to point out, some of the difficulties that we're going to face in what I think is essentially an extremely good direction. Thank you very much.
I'm also delighted to share this panel, especially on such great topics, and probably even more so to be invited by the Czech Competition Agency. I think you have been very innovative over the last couple of years, and I'm sure we'll get a chance to explain why that is. But for now, going to this issue of sustainability, there are three levels I would like to distinguish. The first one is the legal basis for agencies to take sustainability into account. And in my view, it deserves a preliminary question before the Court of Justice. And I think maybe we've been rushing a bit too much in saying that we can take it into account. Let me explain why. We were shown in the video that introduced the day, the Rome Treaty. And the logic of the Rome Treaty is exactly the one that we have in the TFEU. Article 3, already in 59, was mentioning the fact that the Union has to take environmental protection into account. This was the lex generalis, and the lex specialis at the time was Article 155 of the Rome Treaty. I quote, "The Commission must ensure the proper functioning and development of the common market." Same logic today. Article 11 of the TFEU, lex generalis, I quote, "Environmental protection must be integrated into the definition and implementation of the Union." It doesn't mean that each institution has all the time to take it into consideration. And the lex specialis, Article 101 and 102, they do mention that they sanction practices which are incompatible with the internal market. It doesn't say with the objective of the Union. And even Article 101, paragraph 3, gives an exemption when there is technical or economic progress. So for that reason, I'm not quite sure if the role of competition agencies is to actually take it into consideration, or if it should be taken into consideration at another stage. That's the first point. Second level of the analysis, if there is legal basis, my question is, who can actually decide how we take it into consideration? It seems to me that you may want to hire engineers, especially geo-engineers. As you may know, this takes years of education and research. And I will be more comfortable having those engineers within competition agencies than having competition experts such as ourselves, and certainly myself, making those decisions. And the very last point that was mentioned already quite a few times is the one of the trade-offs. So should you have a legal basis and the right expertise, then what I would like to see from a very academic perspective is in every decision when we take into consideration environmental protection, the trade-offs being addressed. Let me mention a few. There is one very clear between environmental protection and innovation. I'm not saying that they are always opposed. We've heard already today that indeed they can go in the same direction, very much true, but this is not always the case. And a good example of that, very recent, seems to be the fact that in 2024, every smartphone will have to use USB-C. And you could say that indeed this is good for environmental reasons. It prevents the waste and the fact that every time you change phone, you have to buy a new charger. But what we know also is that should you develop a USB-D, E, F, you can't use it unless the European Commission every 5 years will assess whether or not there is a better technology, pick the right one, and integrate it into a standard. So generally speaking, standard and innovation may create a tension here. A second trade-off that you mentioned indeed, that I've put on Twitter, is one between the environment and consumers. And my question here is, are we comfortable having competition experts making decisions in the space? Would you be comfortable with me making a decision as to whether we should protect the environment or consumers when there is a trade-off? I can tell you, I wouldn't be comfortable making this decision. I would hate to be in such a position. And in fact, I think that it makes sense to think about institutional reforms or to tweak a little bit the way we design our agencies. And maybe it's worth having some elected officials making those decisions, because I think they have the legitimacy that we don't have being appointed within agencies. Another one that would be incredibly interesting as well would be a trade-off between environmental protection and gender balance. Which one do you choose? How do you choose that? And you see that you get into dark and very dangerous territory when you do so. So I guess the overall point is that we have to be careful regarding regulatory capture. Trade-offs sometimes will be necessary, and it's not always the case that more environmental protection is always good for all of the other values that we may want to protect. And so I think it would be great to always be clear as to why we've made a choice. Indeed, you've mentioned the Dutch Competition Agency. There are cases where they wanted to protect chickens, so animals' well-being, versus prices going up. Again, how do you make that choice? So those are the 3 points I would like to mention again. Do you have a legal basis? Not too sure. If so, do you have the expertise? Not competition experts, but people specialized in environmental protections. Universities are creating schools of sustainability. Stanford is one, but it's not the only one. And third, once you have all that, please address the trade-offs in every single decision. So that's all I wanted to mention for this.
Thank you for your insightful thoughts. And as was already mentioned, there is a possibility for the audience to ask questions. So I don't want to steal the audience this opportunity by myself. And therefore, I'm going to move directly to the next topic. Next topic is about tools. Tools that we, competition enforcers, use for our work. And I would like to make 3 or maybe four points. First, when we are using tools which could affect the tools of the others, we should be thinking broadly. And in this sense, I would like to say that not only the competition authorities are the ones who protect competition. At least in some member states, there is also criminal protection of competition done by the police, because usually cartels or bid-rigging are crimes. And also, indirectly, the competition is protected by successful possibility to claim damages caused by competition law infringement. So, in this sense, if we are thinking about our tools, their fine-tuning and using, we should have in mind also the tools and the enforcement of the others. Second, the tools need to be serviced time to time. In this regard, sad to say, I have to admit that we are still among the countries that haven't transposed the ECN Plus directive, but the amendment is already before our Chamber of Deputies, and I sincerely hope that at latest at the beginning of the next year, we have our work done and the ECN Plus is transposed here in the Czech Republic. But what I want to say is that we not only transposed the directive within this amendment, we also wanted to fine-tune one of our tools, and I mean settlement, because we have a great experience with this tool, but after more than 10 years of using it, we found out that we are maybe here in the Czech Republic too generous, and it might hinder a bit effectivity of the leniency policy. So we are trying to fine-tune the balance between these instruments within that amendment. Third point, maybe if we don't have right tools, it would be wonderful to be able to use the results of the tools of the others. And in this sense, we are trying in the Czech Republic to cooperate as much as possible with the police. The police here is the great source of evidence, especially about bid rigging. They usually found evidence about bid rigging when the police is investigating generally other crimes connected with public procurements, like general corruption or public procurement manipulation. And the best way for the police is, of course, wiretapping. And unfortunately, in our legal system, we are not allowed to use wiretaps legally collected by the police as an evidence. And I think this is something we should talk about, and it might be nice to have this, because in the criminal code of the Czech Republic, we will for sure find much less serious crimes causing less damage to the economy and costs less than cartels, and wiretapping are allowed for them. And last but not least, if we have powerful tools, we should be using them with a responsibility. And we have a tool, very effective one. We are able to impose a ban to participate in a public procurement if there is a cartel connected with a public procurement with rigging. But if we have a market which is really concentrated, oligopolistic, or even monopolistic, it's a bit tricky to impose a ban for one undertaking to participate because we might cause more damage than good. So we should be careful when using powerful instruments. By saying this, I would like to pass the floor to Olivier.
Thank you, Camille. Not so fast. I mean, as you just mentioned, as Peter mentioned in his introductory remark, we're not yet there with ECN+. So maybe before thinking about the bright new tools of the future, let's try to all have the tools we have decided we needed. Only 15 member states have fully transposed ECN+, and the date for transposition was in February 2021. So it's collectively not super serious, frankly. I'm happy to say that in this country things have recently moved, and we're very hopeful they will continue to move and it will be satisfactory. We have had to send letters of, we have had to send infringement notices to a number of member states where it did not move. So let's try to complete ECN+ because it's really important for all of us, competition authorities. Now, the second consideration is that, funnily enough, the only competition authority in Europe that does not benefit from ECN+ is the Commission, because the directive doesn't apply to the Commission. So once ECN+ will be fully transposed everywhere, we will be in the strange situation in which our colleagues in the 27 NCAs have more powers than we do have in terms of investigative techniques. And probably, as you know, there is a review ongoing of Regulation 1. This is probably the first thing to address, which is to align the powers so that we all have the same powers, which is actually almost indispensable given the way we cooperate with each other. So the next question is, what else? Well, I deeply think that we need to update our powers permanently. You just mentioned leniency. I'm not sure we need to review in depth the leniency notice, although I think it's still the one I drafted in 2007 that is in force, so that's probably would be worth having a look. Maybe not change, but simply review whether it's still fit for purpose. But we know no later than last week, for example, the Commission published its new e-leniency notice and makes it now a lot more easy for companies that want to report to do it without having to come to the Commission. They can access the leniency statement online in a securized environment. So all this helps quite a lot moving forward the issues. Another area in which we had to confront this problem is the DMA. The DMA will enter into force. Member states, at least those that are willing, will be able to give the power to their NCAs to investigate under the DMA. And it was very important for us that the powers are the same as under Regulation 1, and that the rules of procedure allow to transfer evidence from DMA files to Regulation 1 files or national standards in national law, and the other way around. Why is that so? It's because I guess when we will start an investigation, and that's why the co-legislators enshrined the cooperation mechanism within the ECN for the implementation of the DMA, in many cases we will not know whether what we will find will be exclusively an infringement to the DMA, or an infringement on the DMA on the problem under national law, or an infringement of the DMA on the problem under specific national law, that 19A, like 19A in Germany, or 102. And so it will be extremely important when we will devise our enforcement strategy within the ECN to decide which instruments we want to use and in which sequence we want to play them, and to be very fluid in the way we can allocate the evidence to the various files. So for me, that is an example of the new type of, if not powers, at least rules that we need to be equipped with in a world in which I think DMA is a precursor of what will happen, which is a much more cooperative way of implementing competition law in the EU. I think in cartel it will be the same. I think that the future will be more made of joint investigations, of collective decisions against how we use our different instruments in which sequence in order to be collectively as effective as possible, rather than the traditional way that prevailed after 2003. You have the Commission, you have the member states, and you have a few interactions in a relatively small number of cases. So I think we're moving towards a more global and cooperative enforcement, and for this we will need a number of new tools.
Well, this is certainly a very timely discussion to have during the European Competition Day, so I thank you for that. And I will first say something about what you said, Camille, about the importance of having the competition authority as the sole enforcer of competition law. It is for us very important to provide this clarity for firms. If you have a sole enforcer, and I know this is not the case everywhere, but if you have a sole enforcer, it makes everything much clearer to everyone. So we should not, where we have the situation, we should not take it for granted. In our case, I should just mention that we have inscribed in the law the relation between other agencies and the competition authority, in the sense, for example, that sector regulators have the duty to report anti-competitive behavior to the competition authority. But having said this, I will go along the lines of what Olivier has said about the timing right now. I think this is the right time for implementation and give way to the ECN Plus to fully blossom, if I may say so. Before thinking about other ways to improve this. We still, as you mentioned, Olivier, we're still not done entirely with the transposition across the EU. There's also a role for the European Commission to check, if I may, whether the transposition has been clearly done. And after that, I think we can all agree that there is no over-enforcement of 101 and 102. So we should make use of our powers that we had already in the ECN and now ECN Plus to do our utmost for competition enforcer. Now, having said this, I will focus a little bit on cooperation and what the ECN Plus really brings us. And it's important, as we see more and more in our cases, the need to involve other competition authorities in the EU. And not just in the EU, but I will get to that later. So, as you know, the ECN directive seeks to ensure that there are no safe havens for anti-competitive behavior in the EU, and it has been quite successful in the past. Only with ECN. ECN Plus allows to go further, and it allows, for example, for competition authorities to notify SOs and decisions in their jurisdiction on behalf of other competition authorities. And this ensures that firms do not get away if they are not established in the member state in which they are operating. Competition authorities can also request that fines are effectively paid in other member states to their benefit. And as I said, we see this need more and more in every case we open as we go through. There are clearly more cases in which we're not isolated in one jurisdiction. But the question is looking beyond ECN+, and I think we have a very positive experience with the ECN, and I'm sure we'll also have it with ECN+. And maybe we can inspire other jurisdictions in the world to cooperate as we do. And I feel this whenever we speak about the ECN and how we cooperate together, that other jurisdictions look to us and aspire to have such a cooperation agreement. And maybe we can aim to achieve cooperation also outside of the EU, because some antitrust behavior or some anti-competitive behavior, namely cartels, actually affect our countries. They affect our jurisdictions, and in some cases we cannot do fully what we can do within the ECN, within our current framework. So what are we aiming at here? We are aiming at keeping members of cartels worldwide from finding a safe haven and hiding behind legal gaps. And this international cooperation has been made possible in other fields after significant events. I'm thinking about the financial sector, and how after 9/11 and the financial crisis in 2008, cooperation became much wider and much far-reaching than previously. So maybe this is just a forward wish. We should aim at achieving that as well, to our benefit in our jurisdictions, in order to fight anti-competitive behavior. Thank you.
Thank you very much. Maybe I want to make a point which is directly related to what Margarita was talking when she was talking about the cooperation between the EU or the member states and non-European countries. It seems to me that there's been a really important change with the emergence of the digital economy, because a lot of the practices of the digital platforms are absolutely the same, with exactly the same result in every jurisdiction. Now, we do have a principle of cooperation agreements where the idea is that each competition authority decides for its own which cases it wants to bring, and then there's a possibility to cooperate on some of those cases. There may be something else that one would that would be useful in the digital sector, which would be not so much cooperation on cases which are brought individually and independently by competition authorities, but coordination on cases. That is part of the new instruments of cooperation that we may, or the enhanced cooperation that we may want to look at, because does it make sense to have 15 jurisdictions reviewing price parity clauses in Booking.com? Isn't that a terrible waste of the money of competition authorities? Isn't there a better way to try to deal with those issues which are the same across the countries? So I just want to point this. Now, coming back to the EU and the ECN Plus, and I think there were two ideas. Of course, one of them was to homogenize the powers of the competition authority. The other one was to try to strengthen the enforcement at the national level in complement with the Commission. When thinking about strengthening enforcement or homogenizing enforcement, I think that there are some obvious levels. One of them is substantial convergence. This is not an issue in EU. Then there is the issue of the convergence of the powers and the tools. But there's one dimension which is not talked about, which I think is really important, which is what are the standards of proof in the different jurisdictions, and what are the standards of reviews by the courts of the decisions of the competition authority. And there's a very wide diversity. First of all, they are at the EU level, there seems to be a change, at least in the court, if I think about the Hutchinson-O2 merger case, for example, where the court has decided to, I mean the general court, because it's now appealed to the Court of Justice, but has decided to ratchet up, really, the standard of proof, and has faulted the Commission for not having met this higher level of standard of proof. So we need to have, first of all, clarity at the European level. What are the standard of proof which are expected from the Commission? Same thing at the level of the member states. And there are very wide differences going all the way from beyond a reasonable doubt, of course, but those of you who have criminal sanctions, to very low levels, more likely than not, or the balance of evidence. As long as national competition authorities have different standards of proof, we're not going to get the same result. The same facts are going to lead to different results in different jurisdictions, and we're not going to achieve the kind of harmonization that we think. So I'm just saying that this is an added piece in the puzzle to try to strengthen the harmonization of the enforcement in the EU, and something that, a discussion that maybe we should have in the future.
Take this one.
Thank you.
I have 2 points I would like to make. And first, I will come back to what you mentioned, Camille. I thought this was very interesting. And having discussion with competition agencies, I hear that a lot, that there are complaints at the national levels that competition agencies cannot fully cooperate, or at least use the data of other agencies within the same country. And while indeed we are still waiting for the ECN Plus to be transposed in many countries, we have more regulation coming and act at the EU level. I think to some degree the Data Governance Act is going in the right direction to try to facilitate the use of data amongst agencies. And we also have the AI Act that is, I think, relevant to competition agencies beyond the ECN Plus. It does limit the use of public data by administrations. My concern is twofold. One, I think it will become incredibly hard to read, knowing that we are still waiting for the ECN Plus to be transposed. We have all of those regulations coming. They may apply at the EU level, but at the national level, you may have different rules depending on each of the member states as to when you can use data coming from other agencies. And second, I think they may conflict. To give you a concrete example, this is something that I discussed quite recently with Axel Voss, the rapporteur in charge of the AI Act, before the European Parliament. And we came to the conclusion that if you want to comply with the AI Act, meaning that you have to train your AI system using databases free of errors and non-discriminatory, it might be that you will have no choice but to infringe GDPR. To be very concrete, if you need a data set that represents the entire population, race, gender, and so on and so forth, it means that you need personal data, and if you don't, then how can you ensure that the data set is not creating any sort of discrimination? I would love to see how the ECN Plus will interact with the Data Act, AI Act, Data Act, etc., and see if there are conflicts. This is a concern, and I think this might be the role of the European Commission to try to harmonize all that. So this was the first point. The second one, and I will here come back to cooperation between competition agencies, something we are trying to help with at the Stanford Competition Antitrust Project is to help with the implementation of the cooperation that is being implemented in the ECN Plus. I would love to see agencies pulling resources together to create new systems to better detect infringements and analyze the case law. Some concrete examples. The Czech Competition Agency and some others are working toward developing machine learning system to detect big ringing. And it seems to me that you could indeed develop such a system at the EU level and deploy the same system toward all of the EU member states. Another example might be to perform network analysis. It sounds very scary and complex, but it's not. What you do is that you take the case law of an agency, You decide on the variables. It may be the name of the parties, the type of practice, the amount of the fine. You put all that into an Excel table. And out of this, you may then do what we call network analysis. You group decisions together, you create clusters. We've done that with the FTC case law, and what you will see is that certain practices tend to come together, which is not something that you can see just reading one decision after the other. But if you do the analysis, it will become apparent that two different unique practices are usually implemented together. I would love to see that at the EU level, and I think we could learn a lot if we were to create such a network analysis with all the decisions coming from the member states. A last example might be retrospective market studies. I understand that the budget resources are very scarce, but it might be something we want to do, especially when it comes to merger control. And to be very concrete here again, what you can do is that if you take the public documentation that companies have to release, financial statement and so on and so forth, and apply natural language processing, what you can do is measure the type of competitive pressures that companies are feeling after the merger versus before the merger, see how they react. And again, it seems to me that you can't just have one country performing this analysis because the data is too scarce. You may want to pool resources and analyze the public documentations coming out of the companies in all of the member states. Then you can get to a very concrete result. So I'm going a bit beyond the ECN+, and I'm sure we get a chance to discuss all the progress that there are being made in the space, but this is something I would like to see more, I suppose.
Thank you. I think, Thibault, you made just a brilliant transition to the last topic, and honestly, you took me some of what I wanted to say, and because we are a bit behind the schedule, and I am the last person willing to stand between you and the upcoming lunch, I'm going to do only the general introduction of the panel and give the floor to the others. So, algorithms, machine learning, blockchain, big data, of course, this is reality. Artificial intelligence becomes more and more sophisticated and better. Nowadays, AI chess programs are way better than any human being. The chess AI plays their own championship. AI is able to learn, to write, to read, to decide, even to paint a picture based on a text. These are also tools, and for competition enforcement and enforcers, it means threats and opportunities. Threats, of course, collusion of algorithms. If the algorithm is designed with the intention to collude, I am pretty sure that it should be considered as a breach of the competition law. But what if AI decides on its own to collude? And are we even able to recognize this? Hard not to crack. From the other side, opportunities, of course, the data are increasing every single day, every single second. How to use it. And Thibault mentioned that it's a real problem. The state, at least in the Czech Republic at the national level, the different enforcers, different bodies have data, but the data isn't possible to combine effectively, and not because of data, but because of the legal basis. And I really think that the combination of data might help not even the competition enforcers, but also the others. So this is probably really the way where we should look ahead. By saying this, because I promised just a short introduction, I'm giving the floor to Olivier. Thank you.
Well, I'll try to be quick, because indeed we're running out of time. Of course, the digitization is creating numerous problems, and not only when we're investigating in the digital economy, because digitization is now pretty much everywhere. It's in finances, it's in particular in payment, it's in energy. We're discovering it as we speak. It's really everywhere. So rather than taking it from the point of view of the challenges it raises, it's what is it we can do? So how can we use new tools, and which new tools? Well, we're already doing it. I mean, the example in bid rigging that you took is very well taken. I mean, I remember when I was working for the French authority a very long time ago, I was involved in an investigation into a software that was called Drapeau, and Drapeau was a software that was made to generate randomly competing offers for the same bidding, so that it cannot be detected, because, you know, it's very costly to generate competing offers seriously, because you need to research, etc., and you know you will not get the job. So that's why in the good old days it was easy, because you immediately saw the tender was rigged, because you saw that the number of offers were just here to cover. With Drapeau, they moved one step forward, because they were using the same deep analysis, and then simply moving a bit of variable, generating a number of other offers that were, of course, a higher price. And it was more than 30 years ago. So it's not exactly yesterday that it started. So what could we do about it, and what are we actually doing? I mean, as you may know, the Commission has a unit that is dedicated to this since 2016. And we are planning to strengthen it, as I said, because it is more and more needed in digital, it is more and more needed in cartels, it is more and more needed in merger. In merger, the flow of data you received for a large merger is just impossible to deal with unless you start to develop AI solutions. So, I mean, maybe this kind of race to the top is not what we should do. Maybe we should go back to something more simple, but it's very, very difficult to curb that tendency. So we are taken in the race to the top, for which, frankly, enforcers are not the best equipped. We have less money than the private sector. We have less resources. In a big case, it's not unusual that my team of 5 is meeting a team of 100. When you add up the various law firms that are consulting, the various economic consultants, the hordes of lobbyists, you end up with 100 to 5, with considerable money to buy a number of IT solutions to flood us with data. And then we need to do something with this data, because of course there is a lot of noise, but in the middle they are inculpatory and even more problematic sometimes exculpatory evidence that you cannot just keep unnoticed, because otherwise you jeopardize your case. So we are equipping ourselves with digital enforcement capabilities. It's my single biggest spending in DG Comp. It's in the area of 4 to 5 million per year, and it's not enough. So that's really a considerable challenge. What do we do with this? Well, first of all, collect and analyze publicly available evidence in order, like many of our colleagues, and then I take your point, Thibault, it would be good if we could do it together. Although some markets are European, some markets are national. Sometimes what you see at national level, if it's a European infringement, is a distortion of reality, and you may miss the big picture. So it's complicated, but we should try to be better coordinated in that respect. But what you can see through a systematic analysis of data is that markets do not function the way you would expect them to function. And then you can launch an investigation on that basis. So we do this increasingly. We deal with this vast amount of data in order to try to sort out the noise, as I call it, from the relevant evidence. That keeps busy quite a big part of our capacities. And one of the problems we have is that I have, as Director General, to allocate machine time to my competing priorities. So if for 2 days we are sorting out the submission in a merger, that means our computers are not available to work on cartels. And that's a problem this scarcity is a problem we face increasingly. But also, increasingly, what we do is we audit the algorithms that the company have created, precisely to check what you have mentioned, Camille. And maybe last but not least, there is a challenge of investment. There is a challenge of keeping up with the pace of technology. But the biggest challenge is recruiting people that are properly skilled and trained. Data scientists are a very scarce resource. And to be frank, even the salary that you can offer in the Commission are not so attractive for these guys. So I guess it's not any better with the various colleagues in the NCAs. And it's a big problem for us, attracting the right skills. And that's why, with my colleague Roberto Viola, with whom I share the implementation of the DMA, and he has the DSA, and he has the Data Act, we have decided that it was probably smarter to have one single big pool of data scientists that we will use for these various aims than having small pockets that are working on the various instruments. Thanks.
Okay, so I will say that we have in the past few years taken stock of what the main risks are in terms of collusion in the digital space or abuse of dominance in the digital space, and it's now time to handle those risks and tackle those risks and do our utmost. I agree with Olivier, we will always be fewer in terms of staff, fewer in terms of resources, and this is why it is important to focus on the higher risks, on the bigger risks, and the ones that have a higher impact on the consumer. So, to take our experience, for example, we have been monitoring the monitoring and pricing algorithms that can be used to foster collusion in digital markets. We know that they make it easier to detect deviations, and we found, for example, that it is much more likely, there's a higher risk that on highly concentrated markets, if firms use a common developer, there may be something behind it, and so they may be using, for example, to coordinate pricing strategies, especially when we see that the developer advertises that it is able to increase margins for the users, for the firms using it. So again, as I said, focusing on the higher risks may be a more profitable strategy for agencies, profitable in the sense that it delivers more to the consumer, of course, and then given the high degree of digitization that has been occurring and accelerated with the pandemic, I'm pretty sure we'll not be lacking cases either at the EU level or at the national level. So it's something that we have been preparing for, and it's now time to act. We've taken stock of what the main risks are. So I will say that in terms of what is possible to do right now, and taking again our example into consideration, we created a task force that is made up of staff from the antitrust department and staff from the chief economist in market studies area, and they are tasked with analyzing the complaints that come forward to us, and which have some sort of digital background. So what have we been doing? We have been using web scraping tools, collecting large volumes of online data, especially on prices, in order to check whether complaints about price alignment are valid, and then we may choose to investigate. This has been helpful in opening an investigation and to obtain search warrants. And finally, we've also been increasing our ability to work on bid rigging and trying to detect from a large database of public data, public procurement data, a 14-year-old database, or a 14-year-long database, if I may say, in order to perform better when we receive complaints and be able to investigate even beyond the complaint that we received and extend the investigation to more years and more procedures. So there's certainly a lot we can do. We will always be, of course, running against a big tide, but we can certainly continue to do more. And I'll pass on maybe to...
Okay, I've got three points that I would like to mention. The first one is the fact that competition authorities are only one of the authorities that are interested in data and mostly trying to ensure that there is accessibility to data sets. But in all of our countries, we have other regulators who have different interests. One of them is to protect privacy. Another one is to keep the data safe. A third one is to protect the consumers. So it's clear that we need to come together. There is a proposal, for example, in the UK, but in the context of the CMU, to have a forum of all the regulators. It's already a reality in the UK, where all the regulators come together and hash out their differences and find the compromise, the trade-offs that are necessary. I think that this is an absolutely necessary discipline. Second point, there's been lots of initiative, we just heard about Portugal, to try to use artificial intelligence or data and analysis of data to try to find regularities and possibly to find anti-competitive practices. There have been examples like this in Brazil, in Canada, and as well in the EU. Maybe now is the time to come together to discuss this, to see what has worked. Has it made a big difference? Has it not made a big difference? How powerful are those tools and how we can improve on them? Simultaneously, we haven't talked about it, but blockchains, very useful for people who want to hide things, very useful also for competition authority, at least potentially, for example, to monitor remedies. Okay. So we've already had a discussion like this at OECD, but it's clear there that there is more scope for competition authorities to use blockchains in order to help them monitor what's going on. Third point, auditing algorithm. We've heard this from Olivier Garçon. It's unproblematic in some cases, and it's not going to solve anything in other cases. If we have algorithms that have instruction to follow the leader, to monitor what the others do, or to signal, it's clear that this monitoring of the algorithm or the auditing of the algorithm is going to help the competition authority say, okay, there is something like a meeting of the mind through this kind of instruction. But if we get into machine learning, it's a black box. And the reason is that artificial intelligence didn't develop by mimicking human intelligence. It developed in a different way. The best example I can give is Libratus. 5 years ago, there was a machine learning algorithm developed by, in the US, developed to play poker. Okay, and there was a test, and the test pitted the computer and the algorithm against the 5 best poker players of the time, and of course the machine won. What's interesting is that there was no instruction in the algorithm. There was only an indication of what was winning and what was losing, period. Okay. What did the machine do? It figured out that if you want to win, you have to bluff. And it learned how to bluff, which it didn't do at the very beginning, and then eventually it won. Now, this is typically a case where you can audit the algorithm as much as you want. You will never find something that says you should bluff, because that's something that the machine discovers by analyzing the past data. For those cases, we do have a legal problem. Parallel behavior is not a violation, a competition violation. So what is a competition violation is a meeting of the mind. In such cases, there is no meeting of the mind, but there is a collusive equilibrium. So can we keep on living with the same idea that parallelism of behavior is not anti-competitive in the face of such algorithm is a debatable question. The only way you can deal with those algorithms is by restricting the data that can go into the algorithm. So you can tell the algorithm, don't look at the prices of your competitors. But that goes against legal principle that it's perfectly acceptable for a firm to try to adapt intelligently to its environment. And of course, the prices charged by competitors are part of this. So there we have we need to have a real discussion on what the future could be, because our jurisprudence doesn't fit or doesn't match the development of the technology.
For people watching us online, we can smell the food here in the room, so I realize it's going to be complicated. I also promised myself I wouldn't be the one using the word blockchain today, so I'm very grateful that you did before I could. Very quickly, first, not talking about competition law, but just competition. 5 years ago, most of the people in the industry thought that it would be impossible to compete with big tech based on machine learning because you would need huge sets of data, and without access to those, you couldn't develop a product or service that would be better or as equally efficient. This is not what we've seen in recent years. If you look at computer science literature, you could read about less than one-shot algorithm, plastic data, where you basically create new data out of existing data, and so on and so forth. And I'm sure most of the people in the room have heard about GPT-3, DALL-E, Hugging Faces. Those are developed by small teams, and what we see now is that there is a competition where, in fact, you can develop very efficient AI system based on less data than what was required just a few years ago. So I think it's very interesting to look at computer science to better understand the competitive dynamic. That was the first point. Looking at competition law and the level 3 type, algorithmic collusion type, still waiting for cases. Doesn't mean that does not exist. But for the best of my knowledge, we have not seen those practices being implemented, which leads me to enforcement. Well, I'm biased, but yes, I think it's an excellent idea, and there is a few points I would like to make. I mentioned that the Czech competition agency is very well advanced in the space. Let me give you some concrete examples. The agency is working on a project called Data Cross 2, where they use AI to detect big ringing. They also have another project called Certifix, where they try to untangle common ownership and use AI to better document all that. This is good. We see more of that coming within pretty much all of the competition agencies all over the world. And looking at what's coming next, if I may mention some concrete steps, we have a big issue, which is indeed what you mentioned, Olivier. How do you get attractive? And can you really compete with some companies that will pay 500K for a first-year computer scientist? I'm not sure what's the salary of the European Commission, but I'm pretty sure this is not the same. So that's a big one. Some agencies have figured out a way for them to attract computer scientists, so maybe, again, pulling resources and experience may be helpful. When it comes to detecting practices, we've been focusing for most of this panel on getting the data out there, meaning on the market, but there is also something that pretty much all competition agencies could do, which is to look at their own case law. And again, as I mentioned, do network analysis so that you better understand the evidence that you have, meaning that you know exactly what to be looking for out there on the market. This is something that pretty much all agencies could implement as I speak. And the very last point I would like to make is that when we talk about computational antitrust or the use of computational tools and AI and blockchain, we tend to have a desire to look at it from a confrontational way, right? The agency versus the company. But as we know, most companies do not have a wish to infringe competition law. And I think here we may see in the coming months and years tools developed by competition agencies for the companies so that they can better comply with antitrust when they desire to do so. The French competition agency in a few weeks will publish an article and a graph where they've put together pretty much all the practices related to Article 101 and 102, and you could get a lot out of it. And I think this will benefit companies where you see which cases are the most important in the French competition agency case law. Something else, and I will actually publish that later this week, could be to develop what I've called an antitrust API, where what you will see is a box with questions, and answering the questions by yes or no will lead you to a first assessment as to whether the practice may infringe antitrust. The way I've done that is quite easy. You take the case law, you put it into a decision tree, and you automate the decision tree into an API. It's not perfect, but this is a good start, and I think it may answer many of the questions that companies have on the market where the practice is obviously anti-competitive or obviously pro-competitive. Some more time, it will be on the gray area. But again, this is the type of tools that I think competition agencies could develop, and I'm more than willing to assist competition agencies should you wish to develop such a tool and offer that to the companies on your jurisdiction. So thank you very much, and I think now might be the time for the food.
Thank you. Actually, not yet for the food, but we are getting close. But we have two questions for you. I start with the one, Thibault. It's on Thibault's point on legal basis for sustainability. One could point to Article 11 of the Treaty on Functioning of the EU, which can be sufficient in that regard. I agree with trade-offs problem. It can be even more pronounced. How can you measure increase in environment against decrease in competition? Are those values commeasurable? Hard one.
Well, in 1 minute, I think there are two sub-questions. So what I've mentioned indeed is that Article 11 of the TFEU is the lex generalis. It looks at the objective for the entire union. And then if you look at what the Commission is doing, especially the DG Comp, it does not mention that overall objective. It mentions to protect the market. Now, should you consider that it's sufficient as a legal basis? How do you address and how do you make a decision when you face such a trade-off? I think we have the experience of what they've done in the US with the rule of reason, where we tend to think that the rule of reason equals balancing the pro and anti-competitive effect. But if you look at empirical data, 95% of the time, when they go for the rule of reason, they have a clear legality test that looks more like a decision tree, right? Where you fill the conditions or not. There is no balancing because the balancing is too hazardous and hard to perform. So I'm not sure what could be the legality test, but I think this is, and also what you mentioned, Oliver, something that maybe we may want to come up with instead of just saying we should balance. To provide more legal certainty with yes and no's might be what we may want to achieve.
Can I add just one point to this, which is one of the ways to do that, which is more qualitative than quantitative, is really to introduce a notion of proportionality. I mean, you look at what is the expected benefit, you look at the other practice, and somewhere you make a decision, a quasi-legal decision, but the proportionality is very much a legal concept, to decide that, yes, it is proportional, it is acceptable. So I think that's one of the ways to bypass the very complex task of, and I must say that one of the dimensions, the non-use value to consumers, is going to be extremely difficult to measure, because consumers are not necessarily consistent in their assessment, okay? So there it's clear that there's not going to be a mathematical answer to the attempt to try to balance the cost and the benefits.
So I think we've answered Yuri's question. And now there is one for Mr. Gilson. Are you in a position to say when the draft horizontal guidelines will be adopted, noting that the 2 block exemptions are rolled over? And do you anticipate significant changes to the draft chapter on sustainability in the final guidelines? If so, can you tell us more about these?
Okay. Well, the goal is to have them adopted by the end of the year, unless, well, and if we cannot make it, we will have to prolong for a couple of months the existing regime. The answer is I don't know. I don't think we will significantly change the chapter on sustainability, and this is because it's very difficult and sometimes not advisable to give guidance on something you have not really practiced yet. So what we wanted is to give a signal, which I think we gave. Now we need to see how we can implement together this guidance. And I guess that part of the guidance will be revised pretty soon in the light of experience. But you know, the only time in my life where I tried to give guidance before having practice was a very long time ago when I drafted the first guidelines under the merger regulation. And we drafted a set of guidelines because although we had never practiced the merger regulation before, because it didn't exist, we thought companies needed some form of first guidance. And they were all outdated after 6 months, because of course reality brought a number of problems that we had not anticipated. And also for the problems we have anticipated, we thought that what we thought theoretically was not working in practice. So we had to change all of the guidelines after a year. So that's why here you will maybe not find the degree of precision you would love, especially the lawyers and the assistants. But we need a bit of flexibility in order to both give the signal, be able to make it work together, and probably, in the light of experience, relatively quickly come back with an amendment that will take into account this experience.
Thank you. Thanks to all of the speakers, Kamil Nejasklep, Olivier Gersan, Margarita Matoserosa, Frédéric Geny, as well as Thibault Schreppel, for their points of view and also raising another questions that we'll have to answer in the process. So thank you very much. Thank you for your answers, questions and your answers. This was the first panel of the European Competition Day in Prague. Now we have 75 minutes for lunch, and at 1:30 p.m. we meet for another important topic. This time, ne bis in idem principle and competition law enforcement. Until then, bon appetit, and see you back here at 13:30. Thank you again. Welcome back to the European Competition Day. This time a video took us on a tour around the Czech Republic. I hope you enjoyed it and that you take it as an invitation to see more than on the beautiful Prague Castle, but also some more places of the Czech Republic. But luckily for you, The Czech Competition Authority have chosen the Prague Castle as the venue for our meeting, so you see one of the most beautiful places of our country. By the way, this building, when we are meeting, I already said something about it, but it was quite badly damaged through the Second World War. So it had to be repaired in the 1950s. And because nobody really knew what was originally on this graffiti on the wall, the communist regime decided to put there their symbols. So that's a task for you after this conference, to have a look and find what they left there as a symbol that it was rebuilt in 1952. I just tell you, it's a sickle and a hammer there, and you will find it somewhere on the top, on the left side from the big window. I'll not tell you which one. Anyway, there are still two more important topics ahead of us to look at in more detail. This time we are going to focus on the ne bis in idem principle and the competition law enforcement. Here the panel will focus on the basic principle of the application of criminal law in a legal state. However, the application of such principle within EU still raises many questions, and that will be the topics for our panelists. Let me welcome Michal Petr, the head of the Department of International and European Law at the Faculty of Law at the Palacký University in Olomouc, Czech Republic, previously worked for the OECD or for the Czech Competition Authority, and will moderate this panel. We also have Michal Bobek, a judge of the Czech Supreme Administrative Court and a visiting professor at the Institute of European, International and Comparative Law at the University of Vienna, with previous experience from the Court of Justice of the European Union in Luxembourg, besides others. Renato Nazzini, a professor of law at King's College London and a partner of LMS Legal LLP London, used to work as Deputy Director of Legal and Policy at the UK Competition Authority, and Csaba Rigo, President of the Hungarian Competition Authority, a graduated mathematician with wide experience from the private sector. And again, for you, there is Slido application to ask your questions. There will be different topics that our panelists will go through, so you may ask immediately when they discuss the one topic. And if there will be questions, I'll try to step in through the panel to ask the questions accordingly to the topic. So now I give the stage to our panelist and Michal Petr, who will lead this panel.
Thank you, and good afternoon to you, ladies and gentlemen. First of all, I would like to express my gratitude for the opportunity of being here, and especially for the magnificent team of the panelists the Czech Competition Authority managed to assemble. With them, I'm confident that we will be able to keep you awake even in this time after the lunch. And we will do our best for you to stay with it. And as you've heard, we encourage you to pose questions to us, especially during the discussion, so that we can stick to the topic and think more about it. As many of you know, the ne bis in idem is my beloved topic. I spent many years researching it and writing a thesis on it, so I would be able to talk to you myself for 2 hours about it, which I will not do, don't worry. Instead, I will let the others speak and only give them floor. Still, the topic is so complex that we decided to go through only with several aspects of it, about 5 of them. We will start with the fundamental question, which is idem. What constitutes a single conduct for these purposes? What is bis? What constitutes the proceedings that after having ended is not supposed to start again? How does the parallel investigation within the EU work? The situation when the same international conduct is being investigated in several competition authorities, in several jurisdictions. The problem of parallel application of competition law, the situation in which the same conduct, the same facts are assessed according to two legal regimes, the national and the EU competition law. So we have a lot to discuss. So we will start with the first topic, the issue of idem. What constitutes the single conduct for the purposes of ne bis in idem principle, and what test should be used to identify it. We grew accustomed to the position of the Court of Justice of the EU, stating that in the competition law, the test is the so-called three-prong test, building on not only on the identity of the offender and the facts, but on the legal qualification as well. Whereas in all other areas of EU law, the Court of Justice sticked with the facts-only test, which was criticized in scholarly literature after every new judgment of the Court of Justice in competition matters, but that was it. After Toshiba, I believe that it will be like that forever. But then last year, Michal Bobek, then the Advocate General, suggested a new approach to the interpretation of idem in his report. So I think it's appropriate to start with Michal and to ask him to summarize his understanding of idem, his view he presented to the court, and to comment on the judgment of the court, what they took out of his advice. So Michal, if you would.
Thank you very much indeed. I do not know whether you on purpose invite all the AGs who were not followed to come along and talk of their views which were not followed by the court. But well, let's see how we go there. Hello, good afternoon. I have the privilege of having the next 15 to 20 minutes with you, and my marching orders for that were to brief you in the case law and introduce you into it. When I was, however, asking Michal and discussing, I was told that you are all up to speed and you have read everything. So there is absolutely no point for me to go through the case law and explain it to you, since you might know it better than I do. So what I thought I would be doing instead is two things. First, I would try to explain to you and explain the broader root causes of the problem. Because I understand you are all competition law experts. I am not. I have very little idea of competition law. Quite frankly, competition law to me is one of the many areas of administrative law I am obliged to service, okay? And from this point of view, I know I will be violently attacked later on, but that's fine. From this point of view, I would try in the first part to focus at the root causes why we were having a general problem of non bis in idem in EU law and partly in competition law, and to set out the problems that needed to be fixed and the root causes for those problems. That's the first part. Then I will nonchalantly skip the B post and Nordzucker and rather focus, instead of laying the cases in front of you, focus at the outcome, trying to explain to you how I would understand what the Grand Chamber said and what it means for the future, because I think it's much more important and of interest potentially to you. So, first part, why did Michal write a whole PhD on non bis in idem? And indeed, well, that's more psychological. No, rather, why is it a problem in EU law in general? And why was it a problem of non bis in idem? Well, as was already indicated, over the years, within EU law, we did have 3 or rather 4 different takes of what constitutes idem and how we define what's non bis in idem. We had the old competition law one, starting with old Val Wilhelm and going on. However, quite frankly, if you read that case law very carefully, ever since Val Wilhelm, it was really saying, whoa, different protected legal interest. But nobody ever bothered to explain it in detail. It kept being repeated tantrically, but never, when you look at the detail, it's very scarce on detail. And quite frankly, cases like Toshiba or others were actually decided more on the side of definition of the act or offense, not really that anybody would be diving too deep into how does the protected legal interest at the European level and national level really substantively differ. However, it's absolutely true, we did have the non bis in idem in competition law, which was always a three-pronged test. Then, within EU law, we gradually started developing other regimes. The eldest one came with Schengen cases and the Schengen Agreement, and what is non bis in idem for the purpose of extradition and double criminality within Schengen, from the Schengen Agreement from 1985. And then, it was very clearly from the very beginning only idem factum, okay? No legal qualification, no legal interest matter. It's really just the act or the facts, material facts of the act. Then came later on another strand of cases which came from the area of mostly tax law, mostly value-added tax, okay? Which mostly concerned cases which were within one and the same member state, where, however, you had parallel prosecution in administrative law, or what would under the case law of the Strasbourg Court be administrative criminal and criminal criminal. Think of cases like, oh, you do tax evasion, but the tax evasion was on larger, higher scale, meaning you get to pay the tax, potentially a surplus or a fine on the tax, and you get criminally prosecuted. Is it non bis in idem? Can you have both in parallel? Those were the cases of Menchi and all other cases which also came there. And there the court developed yet again another approach, which was mostly concerned with limitation of rights. Essentially saying, we are not too picky at the level of the scope of right, is it idem? But then one does the evaluation at the level of limitation of rights, which is a bit of the same trick, just reassorted somewhere else, but fine. Conceptually, it's different. Why am I mentioning this? So already within EU law, you had 3 or 4 areas which perhaps for competition lawyers were not of a huge interest, but for a court of justice or other generalists of EU law were unsettling. And they came into outright clash in B-Post. Why? Well, because B-Post concerned a situation at which you had a national competition authority and a sector regulator, in that case for postal services. And then the question becomes, okay, so even if one wanted to uphold Walt Wilhelm and everything else, what does apply here? Because it's competition and something else. Is it like competition, or is it something else, or is it competition and something else? What rules do apply? That's why it became the test where the Grand Chamber, which, and we are amongst friends, so I will be not divulging any secrets, couldn't dodge the question anymore, because it was there, okay? You cannot evade it anymore. Of course, the other one, Nordzucker, was more on the horizontality, and I understand we will be talking about it later on, of the exact definition of the act and the simultaneous or consecutive prosecution in different member states. That's a slightly different story than definition of the protected legal interest. But that's why it blew up. And last point in the introductory part is also amongst the root causes is simply Strasbourg. Of course, we are all human rightists and we all love human rights, but the case law that was coming from the European Court of Human Rights on the definition of non bis in idem didn't help, I shall put it this way. From the point of view that when you look at the older case law, which was in Strasbourg, on the definition of prohibition of non bis in idem in the additional protocol, which of course, because it's Strasbourg, it's always within one and the same member state, all right, or signatory party. But there, where you look into the case law before Zolokutin in Russia, it was actually quite normal. in the way that there was some type of protected legal interest or classification or the crimen, idem crimen considerations being. For instance, I recall when I was reviewing that older case law, you would have even cases from Austria or from other countries which have parallel prosecution for somebody taking away your driving license while being driving and then prosecuting you criminally, that being all possible, okay? Of course, then came Zolokutin in Russia, which is understandable, perhaps, in the particular context in which it was given. And of course, if you have a respondent state, which was the respondent state, then you might have problems on its own. But when you start generalizing them and go for a very extreme vision of idem factum without any legal qualification, you start having problems. Which actually what happened after Zolokutin in Russia, when, as far as I know, about 1/3 of the national administrative courts was sort of in a semi-open revolt because it was simply non-applicable, otherwise you would shoot down anything and everything at the national level. Then, of course, in Strasbourg came AB in Norway, which is, at least on its face, its clarification of the case law. Amongst us, it's a silent reversal, okay? When you read AB in Norway, it actually, after that, of course, we can lengthily discuss what's proximity in space-time and space travel and whatever you like, but of course, in terms of what's permissible after AB in Norway, the gates have reopened. So, these were pretty much the root causes. We had inconsistencies within the system of EU law across the regulatory regimes. We had contradictory, sometimes self-reversing case law from Strasbourg, and all of that was embedded into a case or a situation where the question had to be tackled. Now, coming to my second point on the introductory bit, I won't be sort of explaining in lengthy detail what the court has decided, but I will rather focus on what it means, okay? So, the key takeaways from the Grand Chamber holding. First, you are not special. Sorry, competition law lawyers, you are not special anymore, but you might have got the news after B-Post, okay? However, so it means everything and anything which falls under Article 50 of the Charter, which is the prohibition on non bis in idem, shall transversally be subject to the same test. So, you not being special, even though you insist on that, it's perhaps the bad news. The good news, certainly for the national competition authorities, as well as other administrative authorities in the member states, is the gates are rather open. Because when you read, in particular B-Post, which is then really the leading case on what will be non bis in idem, and the face of it, it looks like idem factum, because the court keeps repeating that it is really the material acts or facts. It's quite funny when you start reading different language versions, then you see chaos, okay? However, it is rather the same facts which constitute the deed, the act, which then will be punishable. However, then the court took over the type of case law which was in Menchi for all areas, which means the standard test for everything else now is limitation of rights. Which means, as applied, a number of things are still possible, even though it's idem factum. Why? Well, when you look into Article 52(1) of the Charter and the transversal provision on limitation of rights, it's the classical limitation of rights clause, which simply says something along the line, well, if you have a legitimate reason, you do not touch the essence, and it's all proportionate, then you are hunky-dory. When you apply it to parallel proceedings, then it comes with problems of its own as regards the foreseeability of all that. And that was something I was trying to push across in the opinions, and I won't be going back to that. However, from the point of view of the administrative authorities, it's actually relatively good news. Because the only thing which has happened now is that the legal interest or the protection of the differentiated legal interest has switched from the definition of the scope of rights to the definition of legitimate interest under the limitation. When you look at the case law, it's exactly the same exercise, which is now, however, at the stage of limitation of rights, not at the scope. Okay? When you look at the outcome of B-Post, then as diplomatically as it could be done, because the Court of Justice doesn't apply national law, but it's for the referring court to do that, but within the diplomatically possible, it was actually clearly stated that there can be parallel competition and sectoral proceedings, but all that equilibristics were done at the level of limitation of rights. So, all in all, as regards the future, I don't think that from the point of view of the NCAs or other national regulatory authorities, B-Post is actually bad news. It's actually rather good news for you guys. It's slightly less good news for the individuals, but well, whatever. So, from this point of view, when you look at it and all the things that will fly, when you go back and look at B-Post, that's fine. When you look at the limitation of rights as applied, it was applied and it was cleared in a previous case, which I already mentioned, Menci, which was an Italian case, which concerned prosecution within one and the same member state. But there, it was tax evasion on a large scale, which was subject to criminal proceedings and administrative proceedings before tax authorities. Even there, the court has found that there is a legitimate interest to differentiate. Well, perhaps it wasn't entirely convincing, but why? But still, there is a differentiated interest, and it doesn't touch the essence of rights, at least according to the Court of Justice. So from this point of view, I don't think that in spite of being no longer special, that the future would be too gloomy for the administrative authorities, because all that simply means that a number of parallel prosecutory regimes are still possible. Of course, the only negative part is that one has to reason slightly more than at the level of the scope of rights in order to explain how and why the parallel prosecution should still be possible. But, as I was trying to explain, there is rather a large margin for the member states in doing so. So, I would stop there. This is pretty much in a clear, short retrospect where the case law stands, at least in my point of view, after B-Post and Nordzucker, which indeed was trying to consolidate the case law and provide one approach. On a concluding, more critical note, it certainly did consolidate the case law because now all the regimes are one, so there is no more differentiation across the individual regimes of administrative law. However, whether or not or how far this will be a durable solution in an ongoing dialogue with the Strasbourg Court, that still remains to be seen, and that's, however, a topic for another time, I suspect. Thank you.
Thanks a lot, Michal. And before we move a little bit on, I would like to repeat to everybody here that you are welcome to pose questions to us. So should you have any inquiry concerning the idem part of Nebis idem, just take your phone and use the slider. But before you think about that, I would now like to turn to the other panelists to comment on what Michal has said, to comment perhaps on this new regime of idem, the new one to bind them all into a single regime. So Csaba, if you feel like adding something.
Thank you for the floor. It was very interesting to follow the evaluation of the nebis in idem principle in the practice of the European Court of Justice. But I agree with Advocate Bobek that the B-Post case is a possibility and advantage for the national competition authorities. It's in the BPOS case, in its decision, the CEU held that the nebis in idem principle doesn't preclude an undertaking from being investigated or fined for an infringement of competition law, even if a final decision has already been taken against the undertaking on the basis of the same facts for breach of sectoral rules, provided that there are clear and precise rules allowing these double procedures to be forcible. The forcible is a key factor, in my opinion, also. The two authorities shall cooperate with each other and act with each other in a manner of consideration. I bring some Hungarian examples also. The cooperation with the regulators and other stakeholders of the sectors is very important. The two procedures shall be carried out in a coordinated manner and close to each other in a timely manner is also very important. And the total penalty imposed is equal to the gravity of the infringement committed. You will see my presentation where there was a Hungarian case and also a case from European competition where the total penalty was proportional, absolutely. The cumulative penalties taken together shouldn't exceed what is necessary and proportionate. It is very important, and essential facts must be the same. This is the substance, in my opinion, the essential facts. Thank you for the floor.
Thank you. And Renato, you would like to add something?
Yes, very briefly, because then some of it, of course, I will pick up in my presentation. But so extremely insightful and interesting speech by Advocate General Bobek. I would just highlight perhaps one thing that, and it is an open question. I myself don't know the answer to that, at least not entirely. But I do think that switching a certain elements of the test from the definition of the right to the limitations should, at least in theory, make a difference. Now, whether it will make a difference in practice, it's quite another matter. But in theory, it should make a difference because limitations should be interpreted more restrictively in relation to the scope of the right. And so, you know, whether there is the same or different legitimate legal interests may be in practice, this should be looked at differently. Also, I think, again, what President Rigo said just now, I mean, I think the court did emphasize in BPOST certain elements that, you know, proportionality, for example, of the overall fine, of the overall punishment, that was, I think, already in the previous case law inherent anyway in European law in any event, but actually having it spelled out quite so clearly, it does now impose a specific duty, and I'm sure it was done previously in a systematic way, just to take into account the previous fine and look at the overall burden, and as Advocate General Bobek said, and give specific reasons on that, because otherwise, if you are the Italian authority, the Spanish authority, and then you don't put enough reasons on that point, then you may have a hard time in your administrative courts, because now there is that proportionality requirement, and obviously that's going to be subject to judicial review. But I did think it broadly BPOST is good news because I mean these different regimes were untenable. BPOST also brings the case law of the European Court of Justice in competition law more generally more in line with the ECHR case law. That's another benefit, I think, because again, having different standards in relation to the European Convention on Human Rights and EU law created tensions of their own, especially for national courts that then would have to apply both standards, obviously, to the same case. So I think administrative judges, also national administrative judges, will be certainly happier with this more unified approach.
Thank you. Michal, would you like to react? I saw you taking notes.
Sure, just perhaps the 2 points I noted. Of course, I entirely agree. And the first point mentioned, let's not, well, of course, one of the root causes, which I didn't go into, was simply that, I mean, it's called angle, and for horizontality and parallelity regimes is a problem. Because when we crafted the first time non bis in idem rule, it was conceived for criminal cases, meaning criminal, okay? Now we have to say criminal in order to differentiate criminal administrative little criminal, and so forth. So, post-angle, the world has exploded, and now the things which would have never been thought criminal are thought criminal, inclusive withholding of driver's license, sanctions, and so forth, on the third prong of angle under the substantive. Which of course, however, enlarge immensely the pool of the things which then are applicable, or to which non bis in idem are applicable, and if then at the same time what goes for idem factum, then nothing is possible really, because everything is precluded by one the other. And of course, the problem gets even larger when you put all that outside of the Strasbourg regime. Because Strasbourg regime, by definition, is always limited to the same signatory party. They don't have transborder scenarios, okay? Whereas in the European Union, that's exactly what we have quite often. Transborder scenarios where diagonally or horizontally more authorities are active. And there, really, if one takes it to the latter, you just hit the brick wall with your head, and that's a huge problem. And it would be in particular a problem for you guys, because then, as a transversal sector regulator for all fields, you would then be pretty much preempted by any specific regulator who was there first, okay? And not only within your same member state, but also across the member state. Think of the most recent case, I don't know, because the court is crazy, and with the anonymization, the cases don't have names anymore, okay? But now it's the case whereby it's a crossbreed in between national data, NCA and the National Data Protection Authority, Ireland, Germany, okay? The National Data Protection Authority was going either Facebook or Google, one of the two, and after them, or for the violation of the GDPR, okay? But then the Germans came, the German authority, and wanted to go after the same behavior under competition law rules. I mean, the case is now pending. I think there was an opinion of an AG, or I don't know where it is. But then it opens up a completely different layer of complexity when you go cross-sector, cross-member states. And the idea which you then find in the case law from Strasbourg, like, oh, would you be so kind as to coordinate yourselves? I mean, it's bloody difficult to do within one and a single member state. The idea you could do something like that across member states, it's borderline science fiction. The second point you mentioned, just a quick reaction, because it moved to the level of restrictions, it should now be, limitations, it should now be interpreted restrictively. I entirely agree on the level of principle. However, when I look at what is really being done, I mean, I still can't get across the standard reasoning when I read at the limitation of rights, the court saying to me, essentially, and now I will be caricaturing a bit, well, because you will be prosecuted twice, there is no problem with essence of rights because you know that you will be prosecuted twice. I mean, if that's restrictive interpretation, I don't know what's large interpretation, okay? The same at the level of qualifying protected legal interest. When you look back into Menche and the idea that qualitatively, by sanctioning, and I stress that, sanctioning somebody in administrative tax procedure, you are pursuing a different interest than when sanctioning the same person for the same acts criminally. What's sort of qualitatively different protected legal interest? And I say sanctioning, meaning fines in administration, not just repaying the tax, potentially with interest. That I could do. But sanctioning above and then criminal, but even then the court goes and says, oh, it's fine, it's a different protected, I mean, it's a different rights and the different interest at the level of limitation. So at the point of principle, I very much agree. In practice, it's rather lenient, I would suggest.
Well, thanks for your comments, all of you. Do we have any Slido questions or not yet? So please if you are interested, feel free to send us a question. Before that, we will move on to the second subtopic, to the BIS part. I would like to ask Renato to open his presentation, and he will be using the PowerPoint. But before he does, of course, he will concentrate on the nebis in idem in its entirety, but I would like to ask you to concentrate on the procedural part as well. We all know that the basic of the idea of nebis in idem is that once the procedure is closed, it should not be reopened. But in the area of competition law, we have specific rules which might be argued contradict this principle. The National Competition Authority cannot decide that there was not an infringement. They cannot issue a not guilty decision. Only they may find infringement or close the case. And if they close the case, they may return to it. We have commitments decisions, specific decisions which do not state there was an infringement, but even though the case has been fully investigated, but again, it is possible to reopen the case even after it has been settled through commitments. So Renato, if you could tackle these issues as well.
Well, at least some of them. Oh, sorry, this is gone to the end of the presentation. Sorry. Sorry. Oops. All right. Okay, this is it. Okay, so thank you very much, Michael. So as I said, I'll just perhaps start now with a slightly stronger focus on competition law. And as we know, the risk for multiplicity of proceedings is really quite significant. I know that President Rigo will talk about national competition authorities and commissions and so on and so forth. So I really will not go there that much, but I do think there is now, as well as the usual internal tensions, national competition authorities between themselves investigating different aspects of one case, or perhaps breaking up one single case in different national cases. Of course, the interaction between European EU competition law and national competition law. Now you have more and more an entirely different kind of set of issues. And I'm talking about, first of all, the increased importance of enforcement in sector regulation, which is really BPOST, and competition law. This is really not entirely new. I mean, sector-specific regulation has always been there for a long time, but I guess fines have become more significant, and sector regulators have been in the recent past, let's say in the past decade, certainly in a number of member states I'm closer to, have become much more active in enforcing aggressively with fines, essentially, rather than commitments, remedies, and if you want, the traditional tools of sector regulation. Together with, and in addition to sector regulation, now you have something like the GDPR, for example. I mean, and the Facebook case that has been mentioned by Advocate General Bobek is a clear example. Now you have a case that can be prosecuted under the GDPR, that can be prosecuted under competition law, as we found out, because it wasn't obvious to me that there was a competition infringement, potentially. And of course, let's not forget consumer law, because similar behavior has been addressed in Italy, for example, under consumer law. And consumer law, again, you know, is it something new that consumer law can be enforced in relation to the same facts as competition law? No, but again, we have noticed a trend in the past 10 years of consumer law being enforced much more strongly and with much higher fines. 15 years ago, who cared about consumer law, right? There was no nebis in idem issue because fines were just First of all, very few, and in any event, very low. Okay, whereas now it's absolutely not infrequent to see consumer law violations punished in major cases with multi-million or sometimes tens of millions in fines. So that is really a completely different type of issue. And you know, how do we tackle that issue? Now, one could be, of course, and should be, the ne bis in idem principle, because I would argue that the ne bis in idem principle is the only coherent set of rules, the only legal principle with teeth that is capable of really giving companies and individual rights in that respect. Now, the other way of dealing with it, and of course I am very conscious that I'm talking to an audience mainly, not exclusively, but with senior competition officials. The other way of dealing with it is essentially coordination between authorities and prosecutorial discretion as well. Obviously, I cannot imagine the European Commission and DG Comp now prosecuting an infringement of the DMA, maybe imposing remedies and fines, and then the day after opening a 102 investigation into exactly the same practice. I mean, the whole point of the DMA was not to how to enforce Article 102. But so clearly so-called prosecutorial discretion, to use a little bit perhaps this more like American terminology, is clearly an important restraint, an important tool. Within the ECN, there is a kind of formalized working relationship, etc. But can we be absolutely sure that, for example, certain member states and certain competition authorities now having new competition tools, I'm thinking about Germany, for example, will refrain from applying that in cases that could be covered by the DMA, for instance. So, in other words, in a constitutional framework like the EU and like the constitutional frameworks of the member states, we cannot just blindly trust the administration or a set of different regulators to do the right thing. We need rights, and hence the importance of the bis in idem, the ne bis in idem principle. The ne bis in idem principle also has a number of other benefits, and I'll first of all, we talked about, and the Advocate General mentioned, the importance of the ne bis in idem principle also in relation to free movement, and that's clearly one of the foundations of the principle in EU law. It's not only a right, it's also something that facilitates freedom of doing business across the EU, because one is subject to multiple prosecutions and punishments for the same conduct in different member states. That clearly is a big disincentive. It's very important for the legitimacy of the system. I mean, a system where, you know, public authorities have several bites at the same cherry, or time and again, will sooner or later be a system which gets into disrepute. And secondly, finally, I think it also does have, and it is something, a theory which is particularly strong in the United States, something that perhaps competition authorities wouldn't like, but it does put some discipline on administrative authorities. If you know that you cannot prosecute, or as a network of enforcers, you cannot have 2, 3, 4 bites the same cherry, then one would investigate more carefully, be more focused on not making errors or mistakes in that investigation that could preclude a further sets of proceedings. Now, talking about, I want to say a few things a little bit more in detail about the B-post test, and I can do that now really more like as a few additional comments to the previous presentation. So first of all, I do agree that in B-post the court, by moving from this three-pronged test to this two-pronged test, in fact tried nevertheless to save as much as possible, or probably in its entirety, a system in which there are complementary responses. This is the test that the court actually took in part from the European Court of Human Rights, complementary responses to the same social harm, and really in a very loaded way moved everything to the limitations prong of the test. One thing, however, and I would agree completely with the Advocate General here, unlike the court perhaps they didn't quite follow the same reasoning, but I would agree, however, that this test that now the court has put forward, for this test to be meaningful, there must be some definition of what the different legitimate interests are. And it cannot just be the case, as the court said in a sentence, again there, to try to give public authorities probably as wide discretion as possible. The court said, well, if proceedings are under different sets of legislation, this respects the essence of the right. Now, the whole point why the legal interest test, at least as was set out by the court before, was subject to so much criticism, is that fundamental rights cannot be subject to purely formalistic classifications. So is it really right that if a dominant company forces consumers, individuals or whatever to give consent and therefore gets a lot of data, because it's dominant and this is seen, for example, as an exploitative abuse, so it's something which harms consumers. I mean, is this interest, just because we label it competition law, really something completely different from the interest protected by the GDPR that protects consumers from giving excessive data to a company, which admittedly may not be dominant, but the harm that we are looking at is the same, okay? So it's not possible just, I think, to look at this legal interest in a purely formalistic way. And the court in B-Post, I think, shied away from engaging really with the opinion of the Advocate General, how the legal interest or the legitimate objective should be defined. And I think that is, however, an open question. Now, after B-Post, what are the outstanding issues that we will need to face over the next years, and starting from now, really? I don't think B-Post, as much as it's a welcome judgment, is really the end of the matter. I mean, first of all, we have oops, don't really. I'd like to pick up on this, the relationship between the DMA and competition law, which is, you can see that as an aspect of the interaction between regulation and competition law. So the DMA, of which we have a final now agreed test, is indeed, as we know, regulation, or at least on the face of it. It's I think the legislature has really gone out of its way, the EU legislator, to clarify that the DMA is not competition law. Okay. It's not competition law, and it's not competition law because it really complements, as recital 10 says, the enforcement of competition law. It's regulation, so it's not based on individualized assessment of conduct, but it is instead ex ante regulation. And recital 11, and I think that's interesting as well, says that Articles 101 and 102 and the corresponding national competition rules concerning anti-competitive multilateral and unilateral conduct have as their objective the protection of undistorted competition. This regulation, the DMA, pursues an objective that is complementary, and that these are really the same words of the court in B-Post, but different from that of protecting undistorted competition. Which is the objective of the DMA? To ensure that markets where gatekeepers are present are and remain contestable and fair. Now, contestable markets, obviously, especially in relation to barriers to entry that are of a behavioral type, and let's not forget that the DMA addresses behavior, prohibits certain behavior of the gatekeepers. So these are what we would call behavioral barriers to entry that prevents markets from being contestable. So now this, for me, is clearly something which goes under the interest of protecting undistorted competition. I mean, it's a subset, it's a kind of subset of objectives, obviously, given the broader competition objective, but doesn't seem to me very different. And as far as fairness is concerned, well, we can discuss for ages what fairness means, but we heard from the horse's mouth, so to speak, this morning, from Commissioner Vestager, that competition law is also about fairness. And indeed, Articles 101 and 102 do use the word fair. So, you know, whether you can just by words ensure that a certain piece of regulation is not competition law and therefore it can be applied concurrently, I'm not so sure. I think I do agree that the Court of Justice in B-Post really wanted to save the system as it is, but of course then, you know, once a judgment is out there, is not what the immediate objective of the judges might have been, but how actually that legal test is going to be applied in practice. So, you know, are there really distinct legitimate objectives in relation to the DMA and competition law? And also, is the test general or specific? So that's another question I would raise. So when you, in other words, when you have an individual case, do you ask yourself the question, is postal regulation pursuing a different interest than competition law? Yes. Okay? Or is the test specific? Is the application of postal regulation in this case and the application of competition law in this case, are they pursuing different interests or not? So is the application of the DMA in this case, is the application of the GDPR in this case pursuing a different objective than competition law? I would argue that when it comes to fundamental rights, the test must be specific because it does have to protect the undertaking, the person in the circumstances, not necessarily general. So I think that will be an important question to be addressed in the years to come. There are also further problems. Of course, coordination between authorities that is a requirement by under B-post. I think the DMA clearly envisages coordination, but will it be coordination across all regulators, across all different aspects? There will have to be an issue, as I said also earlier, which perhaps was not apparent before, about the overall fine being, at the end of the day, proportionate overall. I had one more slide that perhaps I wanted to show you before all of this, which is then finally beyond the DMA, which is, I think, like a case study of interaction between a piece of regulation which, in my view, is very, very close to competition law, is not if not in part coextensive with competition law. There are also a number of further outstanding issues after B-post, and I know that President Rigo will touch upon some of them. First of all, if nebis in idem protects a person from multiple prosecutions and convictions or decisions, is it possible, does it also impose a limit or a constraint on fragmentation of what constitutes the same offense? In other words, if you have a single continuing infringement of competition law, or clearly one abuse of dominant position, does the nebis in idem principle entitle the undertaking to be subject only to one set of proceedings, or can competition authorities subdivide that infringement so that instead of one set of proceedings, I am subject to 5 or 6 or 3 or however many in the discretion of the authorities? Secondly, what types of decision bar a second prosecution? Clearly, an infringement decision bars a second prosecution. But how about, and Michael referred to that before, a case closure decision? Now, we know that under Tele2 Polska, national competition authorities are not even entitled to make a non-infringement decision, and the European Commission almost never, if ever, does it. Again, because the nebis in idem principle needs to be applied by looking at the substance rather than the form, is there a difference? I would suggest there should be. Is there a difference between a case closure, which comes at very early in the case, maybe based on administrative priority? You look at some evidence, you take a preliminary view, and you say, well, this case is not promising, we close the case. Or clearly a case closure which is based on the idea that maybe the case is, the behavior has changed, etc., and is no longer, again, it's no longer a priority, it's no longer worth investigating. Decisions that are clearly, I think, not such to preclude a second investigation of proceedings, and on the other hand, a case closure that, let's say, comes after 2-3 years of investigation, inspections, 2 or 3 rounds of requests for information, analysis of the market, if not a proper hearing, at least a number of meetings with the company, and then the authority comes to the conclusion that the case should be closed, because really, in the mind of the authority, that is not an infringement, or not sufficient evidence has been found of an infringement, notwithstanding a proper and full investigation. Now, I suggest that even if that decision is labeled as case closure, and even if a national competition authority under EU law cannot take a non-infringement decision, should, as a matter of fundamental rights, preclude a second investigation. there is an established case law, and that's my last point, of the Court of Justice to the effect that if if an infringement decision is set aside on procedural grounds, that does not preclude proceedings being reopened, and therefore a new investigation, a new infringement decision, and new fines. Now, from a purely legalistic perspective, that's absolutely probably correct, one could say, because if an infringement decision has been set aside on procedural ground, there is no previous conviction anymore. So we can start all over, everything all over again. But again, as a matter of fundamental rights, do we have to have some limitations on that? Is it really correct? Is it really fair, since fairness is so important, that the same company, the same undertaking can be subject to one investigation, infringement decision, set aside, we start again, set aside, we start? How many procedural errors should the competition authority be allowed? Should there be perhaps a test of, okay, I can reopen the case again, but only if there is a significant interest, for example, in enforcing in that particular set of circumstances, or only if this second set of proceedings is not vexatious or oppressive? These are all questions. I don't have the answers, and my time is up. Thank you very much.
Thanks a lot, Renato. A lot of questions to think about. Gentlemen, do we have comments on what we have heard?
No comment, just one footnote, if I may. I mean, I noted all the questions, and I shall not answer any of them, but no, one footnote, because you mentioned several times also the Facebook case, the cross-regulatory area between data protection and competition law. And the footnote is the following. This case actually shows, partially, for those of you who might not be privy to the GDPR and the new regulatory regime it established, that too much clarity and too much concentration of competition might, in the end of the day, turn out negatively, because it will be stifling the regulatory competition. And then the system will break outside into different dimensions. For those of you who didn't have a close look at the GDPR, it has a very extensive and detailed provisions on a thing which is called one-stop shop, meaning it gives exclusive competence to one national data protection authority for all trans-border processing which is carried out on the territory, I mean with a controller who has his main seat at the territory of that member state. Translated, everything is Ireland, okay? Which then, of course, surfaced already in other cases before the Court of Justice, and you actually see it bubbling through the system as a deep discontent by some of the other national data protection authorities, because they are effectively precluded from having anything to say by the virtue of the choice of the seat of the subject who is to be regulated. And when you look at the Facebook case in this light, it's simply the system trying to evade, because it's over-concentrated, and we are very clear about who is the competence, but the others are not ready to accept it. It evades into a different regulatory regime, partially on design. I'm not divulging any secrets. When you look into the German debate, I mean, Germans have not been very shy in saying they really don't believe that the Irish are doing a good job. They are not alone, the Austrians are similar, and so forth, okay? So from this point of view, that was the footnote. On the one hand side, we are yawning for the world when the competence is absolutely clear, assigned, and there is a clarity in non bis in idem, but it can go to the other extreme when there is a great clarity about who does it, but the others may not accept it.
Thank you. Csaba, any comments?
Thank you for the floor. I say thank you for the lively and comprehensive presentation and reaction. Nowadays, it is clear that the nebis in idem principle must also be respected by competition authorities. There used to be a view that the principle should only be taken strictly in criminal law. The fundamental law of Hungary also declared the nebis in idem principle in the context of criminal law, which was then interpreted broadly by the judicial practice. You will see in my presentation. You asked whether enforcing consumer protection law on same facts is good or not. The GVH has dual powers, as some of your authorities also, both consumer protection and competition law. We are one of the members of the European Union who has got this kind of rights. 9 members of the European Union has similar. We have a lot of consumer protection cases with big tech companies, and I believe that our procedures and decisions are complementing each other and not competing. I think in that case it is much easier to avoid in idem decisions. This is also what we are waiting from the DMA also, complement the competition law to ensure fair competition. I must say also we have a good cooperation with other regulatory authorities. Thank you.
Thank you. Do we have any questions from the audience? Not yet, but you still have a chance, don't worry. Still have 24 minutes left to pose at least 24 questions, so we can still manage. But before you decide to have a question, I will now pass the floor to Mr. President, to Csaba, who will have a presentation as well. And as specific topic I would like you to address would be twofold. First of all, to share with us your experience as an enforcer of the parallel investigation of the same conduct in different countries, as the Hungarian authorities quite famous for having done. And second, to tell us your thoughts about the parallel application of national and EU competition law. I was always intrigued. What's the reason for that? Why should we assess the same conduct in the same proceedings under two sets of rules if they are identical, as would be the case in Czechia, but probably is in Hungary as well? So if among other things, if you could address these topics. Thank you.
Thank you so much again for coming and for President Mishna for the invitation. It's a great honor to present to you our experience about the nebis in idem principle in the GVH practice. Since the investigation of infringement of competition rules is a parallel competence between the Commission and the national competition authorities, the application of the nebis in idem principle rightly arises in the context of proceedings. Yes, a bit strange. Okay, no problem. Probably everybody knows the nebis in idem principle is attributed to Demosthenes before Christmas. This principle originally meant the prohibition of double punishment. This is the same case cannot again be subject to a judicial decision. The principle of nebis in idem is a principle common in constitutional practice of the member states of the European Union. Its application is ensured by international treaties, as you see, the Charter of Fundamental Rights of the Union and the European Convention on Human Rights. The two latter documents are intended to provide a minimum level of protection. It follows that the actual level of protection afforded to the principle under consideration by different national legal systems may vary from one member state to another. Judicial decisions are of enormous relevance to us in this point of view. 2004 was a landmark in our job as a competition authority enforcing both domestic and EU laws. From domestic jurisprudence, it is worth mentioning the 30 per 2014 AB decision, in which the Constitutional Court of Hungary ruled that the principles set out in Article 28 of the Fundamental Law of Hungary, such as nullum crimen sine lege, the nulla poena sine lege, and of nebis in idem, shouldn't be enforced exclusively in the area of criminal law in the strict sense. Accordingly, the nebis in idem principle should apply not only to criminal law, but also to proceedings classified in other branch of law which seek to sanction unlawful conduct and with preventive or repressive legal consequence. As Michael and Renato mentioned, if administrative procedure give sanction, repressive, that is a legal consequence. The Curia of Hungary also held that the prohibition of multiple decision can be inferred from Article 24 of the Fundamental Law of Hungary. Thus, the nebis in idem principle applies in administrative proceedings. Going ahead, slide 4. The case law of the courts of the European Union on the relationship between the nebis in idem principle and competition law is now considered to be mature. When examining the application of the principle, it is essential to examine the coexistence of three conjunctive conditions, or as you mentioned, threefold test. The importance of these conditions were emphasized by the European Court of Justice for the first time in Aalborg case, but in the Toshiba case also. Unity of offender as a general rule, the subjects of competition supervision proceedings are undertakings business associations. In practice, it would be problematic if the authorities cooperating in the ECN would define what constitutes an undertaking on the basis of different concepts. For example, the European Commission considers an organization to be an undertaking on the basis of effective participation in economic circulation alone, regardless of the examination of an existing absent or absent legal personality or its share of the profits resulting from an infringement of competition law. The second important thing, unity of legal interests protected. I think we thank great for Mr. Bobek for his opinion in this case, in this unity of legal protected. EU law sources protect competition in the European market, while member states, of course, laws can only do so in respect of their own national markets. The nebis in idem principle doesn't preclude the simultaneous action of national and EU authorities in the same case, since they don't apply the same legislation at first sight. The authority of the member states enforces the domestic law of the member states and the Commission the articles of treaty relating to the competition law. If two competent competition authorities would act in a case in application of their national law and would do so successively, in my opinion, then a repeated imposition of a sanction would be in breach of the prohibition of multiple conventions and as such would be unlawful, of course. Identity of the facts, not so easy question, because infringement of competition laws generally can be described as a single natural act. Cannot be described. Offenders usually continuously maintain the illegal state over a longer period of time and while seeking to disjust it. The identity of the act necessarily includes the identity of the offenders. Therefore, these two conditions are worth considering together in practice. The single and continuous infringements may be the greatest practical relevance, consisting of a series of repeated acts, which may be very protracted in time. Therefore, the risk may arise that the competition authority may find multiple infringements instead of a single and continuous infringement that follows a comprehensive plan. Moving ahead to slide 5, the nebis in idem principle has been explicitly taken into account by the GVH in several cartel proceedings, as you see, initiated after accession to the European Union. That was the 1st of May 2004. In relation to the TV and computer monitors cartel case, GVH also initiated proceedings against companies whose unlawful conduct extended to the territory of Hungary until the date of Hungary's accession to the EU. Namely, the Commission's decision didn't cover Hungary in respect of the period before accession. In its decision, the GVA stated that the principle of nebis in idem doesn't prevent the national competition authority of the member state concerned from imposing fines of undertakings participating in a cartel for the anti-competitive effects of the cartel in the territory of that member state in respect of the period preceding country's accession to the European Union. This is only relevant when the fines previously imposed on the cartel members in the decision of the European Commission prior to the decision of the National Competition Authority haven't aimed to sanction these effects. Now, I would like to draw your attention to slide 6. In its proceedings, the GVH expressly took into account the nebis in idem legal principle as follows. You can see the cartel existed before Hungary's accession to the EU. The cartel also affected the territory of Hungary. The scope of the EU cartel procedure didn't cover the geographic market in the territory of Hungary before accession. Without prejudice to the nebis in idem, the Hungarian Competition Authority was entitled to impose a fine for the effects of the infringement in Hungary for period preceding the date of country's accession to the EU. Let's move on slide 7. The parallel application of law does indeed raise the breach of the nebis in idem principle at first sight. But in practice, this is not a problem for several reasons. First, by time of the EU accession, the Hungarian competition rules were fully harmonized with EU rules. Second, Regulation 1/2003 provides for a framework for cooperation between the Commission and national authorities. Third, the ECN system provides the administrative background for member states' authorities to be informed of each other's procedures in a timely manner. Thus, a breach of the nebis in idem legal principle can effectively be avoided. Where the infringing conduct affects trade between the member states, single decision, single penalty, one decision, one sanction. Of course, the authority finds a single decision that there has been an infringement of EU and national competition rules. The amount of the fine doesn't depend on the fact that both national competition law and EU competition law have been infringed. So that infringement of the nebis in idem principle cannot arise. In the context of the GVH experience, it has always been mindful of the Commission's proceedings and even those of the national competition authorities in its operation. This is all that the more easy to achieve given the European competition network, ECN, was created for this purpose. What do you think about the number of cases brought on a dual legal basis under Article 101 and 102? You can see the statistics. Of course, period between 2004 and 2021, as a share of GDP GDP per capita. Going ahead of the cases Bpost and Nordsacker and others, in the practice of the Hungarian Competition Authority, there have been examples for competition proceedings, primarily in regulated markets, primarily in the telecom sector back in 2000s. The regulation of competencies of the regulatory authority and the GVH was sufficiently sophisticated to avoid breach of the nebis in idem principle. Case Bpost and case Nordsacker and the others help national authorities, in my opinion, assess to how to take account of the nebis in idem rules in practice. Moving ahead to slide 10, I would like to draw your attention. The judgment of Bpost is a very good guide for practice in this regard as well. There have also been several occasions in the practice of the GVH that conduct hasn't had not only competition law, but also other sectoral aspects. Due to a nature of ex-ante market regulation, market failures can emerge which may be detected by an ex-post competition investigation by their very nature abuse of dominant position. Let's see an example. In the proceedings concerning in VG 69 from 2005, in these proceedings concerning the infringement of several regulations aimed at market liberalization, the Hungarian National Media and Info Communications Authority also established an infringement and imposed a fine. However, it investigated the infringement only for a limited period of time. In this decision, our authority didn't take into account the relevant turnover generated during the period covered by the decision of the Info Communications Authority when imposing a sanction. So, in the end, no double penalty was imposed. There was a continuous cooperation between the two authorities. They informed each other about the last status of their respective procedures. We mentioned the cooperation. Cooperation, in my opinion, really a key factor. The GVH is continuously cooperating with at least 12 sectoral regulatory authorities to facilitate the proper flow of information. The details of cooperation are set in agreement. You can see the list. Probably Michael mentioned in the German Facebook case, exactly. In parallel with the Data Protection Authority, the Competition Authority also opened an investigation and found an abuse of dominant position by Facebook's misuse of personal data. Here, too, essentially the same conduct was investigated by both the Data Protection Authority and the Bundeskartellamt. Advocate General Rantos said whether a company complies with the privacy rules may be an important indication of whether its conduct breaches competition rules. A competition authority may take account of the compatibility of commercial practice with the GDPR, and antitrust watchdogs, however, need to consult with the lead privacy enforcers as well. Advocate General Rantos refers analogy to the judgment in Bpost, in which Advocate General Bobek delivered his opinion on the basis of which he concludes that there is no breach of the nebis in idem principle in the Facebook case. We are waiting for the judgment. Thank you very much for your attention.
Thank you. Michal, I guess you are not really willing to intervene concerning the practice of the National Competition Authority, but I still would like to ask you a question as an EU law expert, not as a competition one, concerning the dual legal basis of the decisions, the parallel application. Because I remember you touched this topic in your opinion as well. It's safe to say that in Czechia, I would say in Slovakia, in Hungary probably as well, the rules on agreements, the rules on dominance are exactly the same. The wording is identical. In the same proceedings, we are investigating the same case, and at the end of the day, the National Competition Authority issues a decision declaring that 101 was breached and the national equivalent was breached. Do you see in this practice any problem from your point of view? Putting in front of the bracket that it's explicitly provided for in the Regulation 103. So more a general principle-led idea. But you would like to comment on that?
I don't have anything brilliant to say on that because actually I was myself puzzled by that. And so we, with my team, a great team of referendaires, we started digging how on earth it came in. I tortured the poor representative of the Commission about this at the hearing because it's conceptually twisted, okay? Because if there is the idea that, okay, we can discuss whether or not affectation of the trade between the member state is freestanding competition in the test in order to decide whether national competition rules or the EU rules will be applicable. But to say you have to compulsorily apply both is a bit strange because, of course, then you open up the space for the contestation that once you apply directly 101 or 102, it has a transborder element, hence you are covering more than one member state, hence and so forth. As far as I can tell, there is no conceptual deep thinking, but I'm happy to be stoned by anybody who thinks differently and has a better experience, because when we dug really deep, we realized that the original proposal of the Commission, 101/2003, was very much different and conceptually clear. Either you go for the national competition rules, which are, however, fully harmonized and everything, that's absolutely fine. Content-wise, they are the same, but legal basis will be either the national competition rules on substance or 101, 102 directly. And you don't mingle the two, and thereby you have as jurisdictional criteria at the same time. The problem apparently was that in the negotiations, and on that you might be better informed than I am, somebody sort of penciled in the last moment in order to encourage the NCA to engage with 101 and 102 directly, that they shall apply both, thereby blurring otherwise clear jurisdictional lines. So that's, I suppose, as much as I can tell, because there isn't any more brilliant thinking. I mean, the dual basis, I wasn't sure you meant this dual base, right? Because there is also the outstanding question of a dual base as in national legislation for the dual criminality being two separate national legislations. But this, okay.
Well, thank you. Even though you say not brilliant, it's refreshing to hear ideas like that because in the competition law community, this is something which is absolutely not questioned. It's taken as for granted that the dual legal basis is there without.
No, I'm not doubting it. I mean, it's there on the paper, and of course you are obliged to follow that. What I thought the question was more conceptual,
yep, exactly.
And when we start digging, we start having problems. So.
Yep. Thank you. Renato, do you feel like commenting? Or?
No, I don't really have any. I think, as far as I remember, I mean, I was the UK authority in the European Union at the time, and as far as I remember, the reason was exactly that. I think it was feared that some competition authority would not really apply with Article 101 and 102, so there had to be a duty to apply them when national competition authority was applied. And of course, many competition, there is also the practical issue, I think, for a competition authority, certainly, I mean, going back when I was at the authority, that then in many cases, you may want to apply both if they effect on trade on member states is not entirely clear. So if you may lose the case on effect on trade, then you have the national legal basis. And so in reality, I don't know practically, I mean, the effect on trade test is pretty clear and also pretty wide, but I think there was that practical consideration as well, as far as I can recall.
Thank you, and thank all of you, gentlemen. It's been a great debate. We are 35 seconds before the end, but I guess that finally we received a question. Is it so?
Yes. Thank you all as well. And I think this question goes for like a summing up of your discussion, because it sounds, I would ask your opinion whether there are any changes needed in approach or legislation by member states or the national competition authorities to balance the protection of fundamental rights and effectiveness of competition law enforcement in relation to nebis in idem.
We've got another 3 hours.
No, we've got minus 10 seconds actually, but still some answer would be nice. Are there any changes needed?
Maybe Csaba, will start with you as an enforcer.
In my opinion, it is possible to ensure effective enforcement of competition law on the basis of the established case law, not necessary amendment of competition laws, in my opinion. It is already clear that in the future, even greater emphasis should be placed on cooperation between competition authorities and other regulators also. I emphasize this also. Thank you.
Thank you. Gentlemen, any quick response, or we will leave that for the discussion over the break?
I think I agree that we don't need any reforms anymore.
No more reforms would be the message. Okay, so thank you, gentlemen. Thank to Michal Peter, Michal Bobek, Renato Nazzini, and Csaba Rigo. Thank you for listening. I must say you are really doing a tough job when I'm listening to all those topics. Wow. And I guess you need a coffee and some refreshments to get some strength for the third panel, which will not be easier than those ones. I'm pretty sure about that. So thank you for now. We'll have 20 minutes coffee break, and then we'll meet here back in the room again to talk about the important projects of common European interest. So for now, enjoy, and at 3:30 p.m. we start again. Thank you. Ladies and gentlemen, let me welcome you back again to the third panel of our European Competition Day. Now the discussion will focus on important projects of common European interest that are aimed to boost the European economy and should help to close the gap between the European technology sector and the most advanced global economic powers. This is the tool to bring together several member states and their industry with the help of state aid and support breakthrough innovations in key sectors. How has the strategy been implemented so far by now? A topic for our panelists. Petr Solský, Vice Chairman of the Office of the Protection for Competition, with experience from the Ministry of Interior as a Deputy Minister or from the permanent representation of the Czech Republic to the EU, who will be moderating this panel. Also, we have Caroline Butz, Professor of Competition Policy and European Economic Integration at the Faculty of Social Sciences and Solvay Business School and the Brussels School of Governance at the Free University of Brussels. She is also a managing editor of the European State Aid Law Quarterly. Preben, okay, I skipped one. So I start, okay. Preben Petersen, the head of State Aid Division at the Danish Ministry of Business, Industry and Financial Affairs. Previously, he was the head of State Aid Division at the Danish Competition and Consumer Authority. and Karl Soukup, Deputy Director General for State Aid at the Directorate General for Competition, heavily involved in the DG's response to the COVID-19 crisis as well as the current crisis created by the Russian aggression against Ukraine. So, now I give the stage to Petr Solský, who will get us more in detail of the topic, and it's again up to you to ask the questions so that I have something to come up back to the stage with and ask your questions to our panelists. But now, Petr, the stage is yours.
Ladies and gentlemen, dear colleagues, I'm really happy to have this opportunity to speak at this event and present the last session of today's conference. We did not choose the topic of state aid by chance. The recent major crisis which the European Union has been going through, whether it is the COVID crisis or the current energy crisis, once again highlighted the importance of common European state aid rules. That's why we have chosen a topic which is strategic in the long term and at the moment also very relevant. From at least the beginning of the last decade, one can observe efforts to strengthen the position of the European Union and its economic entities towards other global powers in the international economy. On the EU side, there was a clear gap in some promising technological fields such as electromobility, semiconductors, or fifth-generation networks. On the part of the other global powers, there was a clear tendency to support their domestic entities, often to the detriment of the European ones. In response to this situation, in 2014, the European Commission adopted a communication containing guidelines on how to assess under state aid rules the public funding of important projects of common European interest, IPCEI. A legal base for this communication is provided in the Article 107, para 3.b of the Treaty on the Functioning of the European Union. The first Commission's communication was subsequently replaced by the new revised communication in 2021 that reflected experiences from the several already adopted IPCEI projects. This new communication is applicable from 1st January 2022, so very recently. The aim of this IPCEI instrument is to enable member states to combine state aid for these projects with private investment to make a very significant contribution to economic growth, job creation and strengthening competitiveness for the benefit of the EU industry and economy. Another goal is to overcome major market failures or systemic issues or problems of the EU economy and bring positive spillover effects on the internal market and the society as a whole. The core task of the IPCEI is to bring together the public and private sectors in order to implement large-scale projects that will bring important benefits for EU and its citizens. Due to the innovative nature of this IPCEI instrument, the mandatory involvement of at least 4 member states and other conditions set, it took several years to implement a first specific IPCEI project. In December 2018, the European Commission approved the first IPCEI project in the field of microelectronics, involving 4 member states, Germany, France, the UK and Italy. Austria later joined the project as well. The aim is to support the development of the production of key microelectronic components such as semiconductors, chips, sensors, transistors and optical networking elements, which are used in various industries, especially in the car industry. More than 30 business enterprises are participating in this first project, investing around 6 billion euros of private capital, with the member states providing 1.7 billion euro of state aid. Another IPCEI project was approved the following year in December 2019 with the participation of 7 member states with the aim of promoting the production of electric batteries and their components. 17 industrial enterprises are participating in this project, investing 5 billion euros in private capital and receiving state aid of 3.2 billion euros from the participating member states. The third IPCEI project that I would like to mention again concerns the support of automotive battery production chain and is even larger in terms of private investments, having 12 member states participating in this second automotive battery production project. Just from this short overview of those 3 mentioned IPCEI projects, you can see the importance and the large scale of the state aid in these individual cases. And there is the clear intention of the European Union to catch up the lost time in competitiveness to other global players, like I have mentioned. So let's hope that this way will improve, at least in those areas where those projects being implemented, the European economy and industry. The first IPCEI project in which the Czech Republic is also participating is the project in the field of hydrogen technology. Specifically, it is a project aimed at supporting research and innovation and first industrial application in the hydrogen technology value chain, which was jointly prepared and notified by 15 member states and approved in July this year by the European Commission. Member states will provide 5.4 billion euros in state aid, which will be complemented by further 8.8 billion euros in private investment. Iveco Czech Republic company is participating in this project on behalf of the Czech Republic within the framework of a project for the development of hydrogen buses, specifically development of fuel cell production and end use, including operation. From the mentioned overview of several approved IPCEIs, you can see importance and large scope of each individual project, as well as the importance which member states attribute to this area. On the other hand, it's clear that given the large scope of the project, the large scope of the state aid and huge number of participating entities and member states, those IPCEI projects will have logically impact on the competition. So when I choose the panelists and the topics for this panel, I would like to kindly ask Professor Caroline Batz from the Free University of Brussels to reflect on these aspects, particularly with regard to competition. Then in the following contribution, Preben Pettersson will mention some Danish IPCEI projects, again very interesting and very specific projects in the transport infrastructure. And last but not least, Mr. Karl Soukup from the DG Competition will give us details of the European Commission's recent experiences, the way the Commission is planning to go ahead with this interesting tool. And of course, I would like to ask him to mention the new communication guidelines from 2021. So, Caroline, the floor is yours.
Ladies and gentlemen, good afternoon. Thank you for the introduction. Also, thank you for the kind invitation and congratulations on this very interesting competition day. During this panel, we'll focus indeed on the important projects of common European interest, and more specifically, in my presentation, I will try to highlight how they can contribute to sustainable economic growth, also to competitiveness, and try to put it into perspective in relation to our industrial policy, maybe also the topic strategic autonomy, resilience that we have talked so much about lately. It's indeed the case that several sectors, the EU is not at the forefront. If you look at big tech, many of the companies are in the US, many of the big players that are in the EU are in US ownership. China is getting more and more on the forefront in several technologies. So it is time to boost performance in specifically well-chosen key areas. And in order to do this, it is important to join forces and not to have only individual member state initiatives, but to join forces between the member states. And definitely these common projects of European interest are a way to do this. So I will very briefly introduce the topic and then the state aid rules and give a few examples. Highlight also a few trends that we've seen in the evolution from the very early projects, even the avant la lettre projects of common interest to the ones that we have today. Also go into the balancing test a bit, where we balance positive and negative effects of certain projects. And recent news, or relatively recent news from the court, which has surprised us a bit in this field. And then highlight some of the opportunities and threats or the points of attention that we should take forward. So we talk about projects of common European interest, indeed contributing to sustainable economic growth, but broader than that, creating jobs and making sure that we are competitive, not that we have competitive companies within the EU, but also in the global field, that we face global competition. More recently, we've been talking a lot about resilience, and certainly in terms of the recent pandemic and conflict, we seem to be rather dependent in certain areas. So how can we maybe decrease the dependency? We've talked a lot about strategic autonomy. Well, it's quite clear that in some sectors we can move forward a bit, in others we can maybe only diversify among our suppliers, and in others we are very dependent on one supplier, so how to go about. So we'll focus on creating complex value chains to ensure the long-term competitiveness. And in that aspect, we've already mentioned a few common topics, everything related to the twin transitions, so green, everything related to digital and to data, but also broader industrial strategy and next generation EU. A recent experts group report has identified 6 key value chains to focus on. First one is vehicles, not just vehicles, but autonomous, smart, environmentally friendly vehicles. Then hydrogen, smart health, the Internet of Things, low CO2 emission industries, and cyber. So they are identified as key value chains where we need to invest and where there is an added value of investing together, of coordinating the efforts. And to make it even more specific, the expert group has also defined specific topics. So we've looked at batteries, computing, and microelectronics, and not by accident, and we've now also have some projects there. The expert group has also really focused on where are our key dependencies. So what can we maybe improve in order to become less dependent on non-EU suppliers? There we've talked a lot about raw materials, but also batteries, pharmaceutical ingredients, semiconductors, also cloud and edge technologies. So how can we step a bit up? And is it possible to become leaders? Or is it possible in certain sectors to become rather players within the supply chain, but still to take on a role? Or in other areas, maybe it's only possible to try and smartly pick our suppliers so that we are not too dependent on those that may change positions in the future. So in that sense, it brings us to state aid, because if we want to go into those common projects and want to unlock additional investment, it's also important that the member states and the governments have their strategies and also contribute in this funding. And we go to the basis in the treaty, Article 107.3b. And this article has basically not been used a lot prior to, let's say, 2008, when we started using it in terms of the financial crisis. Previously, we had used it maybe in some privatization context and cases, but it really became apparent in the financial crisis that this was a good article to use, and it has basically 2 aspects. So first of all, remedy disturbances in the economy, the financial crisis. We've recently also used it in terms of the COVID pandemic. But the second part of this article says that it is also important to promote important projects of common European interest. And we are in the part of the treaty article where we have an exception to our general prohibition. So it says basically that state aid may be allowed to promote these projects of common interest. Previously, we didn't have a coordinated set of rules or guidance, but we did find references to projects of common interest in the R&D&I rules, in the environmental rules on state aid. But since 2014, we have our IPCI communication, where it's for the first time a set of rules, let's say, that go across all economic sectors of activity, where we encourage multiple member states to join forces on a project, which is always to correct a market failure while adhering to the standard set of principles that we always have. The fitness check has revealed that this communication was fit for purpose, was going after what it was supposed to, that it increased predictability of assessments and consistency, but that maybe some clarification of certain concepts was still needed, and that we needed to look specifically at the situation of SMEs. Because big companies quite easily find their way into these common projects, but for SMEs it's not always as simple. So we need to look at the situation of SMEs, make sure that they easily access the projects and participation, and maybe even have different sets of rules or aid intensities for that. So our 2021 update of the communication, which Carol will go into a bit further, focuses on facilitating more member states to participate and also these SMEs. To make it a bit more explicit, we've had in the very early days, even before the communication was there, 2 infrastructure projects, which were projects of common interest. One, Öresund, link between Denmark and Sweden, which started about 20 years ago. And then the Fehmarn Belt, also linked between Germany and Denmark, 2 infrastructure projects that have gone on for a very long time. And I won't tell you much more about them because Preben will go into these projects. But I still wanted to mention them, as sometimes they seem to be a bit forgotten, as all of the attention nowadays goes to the big value chain examples that we have. Hydrogen, microelectronics, and batteries, as already mentioned. They are in different value chains, seem to unlock the participation of many member states and go into very specific cases. And microelectronics goes into, I'm not sure if you're all aware of the Moore's law. So Moore's law saying that basically the number of transistors per microchip doubles every 2 years. So these microelectronics really go into, we want more and more of Moore's law, and so that we can advance in sectors like chips, semiconductors, etc. Then the batteries also have 2 parts, basically focusing on materials, cells and modules, sustainable batteries, but also battery innovation, and then currently a very big hydrogen project. Not by coincidence, they seem to also be in line with other initiatives. We have the European Chips Act. We also have the Battery Alliance, so they seem to be going nicely hand in hand with this bigger strategy and the industrial policy objectives that we go about. If we go into a few trends, so in the top table you see the 2 infrastructure projects. Basically always 2 member states, logical, the 2 member states that align to make an infrastructure or a connection between the 2 countries. And the table below goes then into the value chain projects. A few trends that we see here over the years. Through the projects, we see more and more member states participating. We see more private funding being inserted, so it seems to unlock a substantial amount of private funding. We also see state aid increasing. State aid increases in absolute terms, but also in relative terms. If you put the state aid in perspective to the private funding, we also see that this goes up substantially. Interesting is that in recent years, we have not seen new infrastructure projects of common interest. Nevertheless, seem to be very important. If we look a bit at the recent evaluations of the Court of Auditors. A lot of infrastructure projects that are shared between member states somehow don't reach their full potential or are not finished. There's these famous pictures of roads and rail being finished in one country, and all of a sudden when you arrive at the border, there is nothing more, so basically stops. So certainly the value of these projects should not be underestimated, and it's also interesting to see how this will develop in the future. I already mentioned in the beginning that in this communication on projects of common interest, we very much adhere to the basic principles of evaluating state aid. So we always have a balancing test, putting the positive effects of an aid to the negative ones. Idea is that when the positive effects outweigh the negative ones, we can go ahead with the aid measure. Now this is an exercise which is not always very much quantifiable. Sometimes it requires a bit of qualitative reflection and to balance what outweighs what in terms of ideology as well. Here it's clear that the common interest objectives are outlined and then the projects clearly contribute: competitiveness, growth, societal and technological challenges. And the Commission is looking in the negative side mostly at distortions of competition impact on trade, but for these projects a lot to potential overcapacity. Doesn't this either maintain or generate overcapacity in a certain sector, but also doesn't it lead to market foreclosure or dominance? Basically two fields, and we should be very careful that it's not the already powerful companies that gain additional market power by joining these projects, and at the same time making sure again that the SMEs also have their role to play. Also looking at access and pricing. Are the results widely disseminated? Are they freely available for everyone, so that the benefits not only are there for the direct partners but also for the indirect partners and the market at large? And then of course being careful of subsidy races. When it comes to location decisions of companies within these projects of common interest, we need to make sure that the member states don't engage in a subsidy race to try to attract the investments in their country. Also an interesting point is that we usually ask for a counterfactual. So what would have happened without the project, so that we can clearly see what is the added value and what was the incentive effect, what has been realized that would not have been realized without the aid measure. Not an easy exercise. It's not an easy exercise when you talk about an aid measure for one company. Imagine trying to make a counterfactual that involves so many countries, so many companies, and so many different players. And so that's almost an impossible exercise, but still a good way of reflecting on the effects. And then we come to indeed the true balancing test and relatively recent case law. I think the state aid field was shocked a bit. It's shocked from time to time by the courts, but certainly on the balancing test in the COVID case law. So I mentioned this article 107.3b has two parts: remedy a disturbance in the economy and the projects of interest. When remedying a disturbance in the economy, the courts have said in the Ryanair cases that, okay, it's remedying the disturbance, so if we can prove that the measure is appropriate, necessary, and let's say proportionate, that we can presume that it is in the common interest, and therefore not necessary to do a real balancing test. This brings us to the question, if remedying a disturbance is definitely in the common interest, what about our projects of common interest? What's in a name? If we cannot assume that these projects are in the common interest, basically we cannot assume that anything is. So if we may derive from the case law that a balancing test is not really necessary, we get into a territory where we basically skip an entire part of our evaluation. An evaluation which brings to light from time to time small but important changes to aid measures, ways of perfecting the aid measures and making sure that we indeed have the full potential. Sometimes there are small changes or small things that are revealed during this balancing exercise, but still important ones. So it is a bit of a pity, even though we see the spirit of the reasoning of the court, it is a bit of a pity to somehow put this balancing test to the side. But still to be seen how this will evolve, as it was the General Court that came up with this point. Finalizing, just some points for attention. Opportunities, maybe risks, and we will also see that many of those go together. When we talk about competitive sustainability in the twin transitions, it is important to basically see this in a very big picture, how to incentivize public as well as private investment, how to make sure that the measures or the projects really trigger additional private investment and don't crowd out stuff that we are already planning or that companies already had in the pipeline. How to ensure the participation of so many companies. If we have many companies, this is important for the projects to reach their potential, but at the same point, it's a major challenge. It is very difficult to align timetables, objectives, so to what extent will we see true cooperations or individual projects under a common umbrella? And so this is to be seen in the future. Why dissemination? Extremely important to make sure that the benefits are available for everyone in the markets. And then reaching or paying very close attention to the productivity gap between those who are already in the tech industry and those who are not, a gap which is specifically prominent for SMEs more than for larger companies. And so basically making sure that our governance is set up in a way that the projects are inclusive, that they are transparent, and that everyone can participate. Also making sure that we align with other policy fields. If we look to our merger control, for example, we've seen that we've been in the past relatively strict. We want to have a certain amount of, let's say, competition in the EU market. At the same time, this means that we have prevented mergers to establish a big company that can take on sometimes maybe global competition. Do we want to keep this alignment, or do we want to allow these global players, these stronger global players, and what point will they also take on in our projects of common interest? Strategic autonomy, then closing. We want to avoid one-side dependencies. As I already mentioned, it became prominent during recent times. And we've gone through, for example, defense industry, a number of levels, because it's very easy to say we want strategic autonomy and only look at the one you buy from. But obviously the one you buy from behind is an enormous supply chain usually. So you want to look at ownership of the companies. To what extent are the companies owned by EU ownership? Look at mergers and acquisitions. Be careful that EU companies are not taken over by other players. Look at tenders, the EU tenders in our, that we are writing. To what extent are they won by EU players or other global players? Supply chain participation, to what extent do we have our supply chain participation with EU companies? And then commodities, and that is probably the most difficult one. If we look at commodities, rare earth materials, lithium, etc., it becomes very difficult to become independent. It becomes maybe for some possible to diversify our suppliers, but we will never be fully able to source ourselves from EU partners. So to what extent can we diversify there or choose strategically? So in conclusion, after a rather, let's say, slow start, there's been really now momentum in the uptake and the creation of projects of common interest. They're overall supported by a very wide range of stakeholders and have enormous potential if we look out for the few, let's say, risks that we have listed. So it's also important, I think, to involve the Commission very early on from the design phase, but I will not go into that, as I think Preben will also give you more details on that. Thank you.
Thank you, Caroline, for your interesting presentation. So, Preben, floor is yours.
Thank you very much. It's a great honor to be here as a state aid person from the far north. I will start just to make one little disclaimer. As the Danish Prime Minister has announced a general election to be held the 1st of November, I think I need to state that I'm not talking on behalf of the Danish government today. At least not the incoming one after 1st November. As it was said, I will talk about two Danish projects and the experience we have from doing these projects. First, I will talk about the Fehmarn Belt link, which is a tunnel infrastructure between Denmark and Germany. And then finally, I will talk about the Danish and also Czech participation in the European hydrogen project, which is a very large-scale project. As you all know, to produce hydrogen is quite simple. You are only electrifying water, and then you get oxygen and hydrogen. But the point is how to do it in a large scale and how to use it commercially. So, yeah, it works. Well, first of all, I will talk about this Danish permanent connection, the tunnel to Germany, that has been through a long and very difficult process since 2014. Already, it started actually in 2009. And it is now maybe ending up in a court case here the 8th of November, because we are not totally agreeing on how to interpret the state aid rules concerning this case. We think it's a true and genuine important project of common European interest, and it is fitting the IPCI communication from 2014. But I will come back to that. And then I will talk about the communication from the Commission from 2021, the IPCI criteria and how to use them in practice. And then lastly, I will come back to the large IPCI projects on hydrogen that has been adopted by the Commission the 15th of July 2022, and also there's been one adopted the 21st of September 2022. If we look at the original IPCI criteria, a project must be in conformity with the Treaty, Article 107, Paragraph 3, Letter B, and it is about aid to promote the execution of an important project of common European interest. And it must be a single project which is clearly defined in respect of its objectives as well as the terms of its implementation, including its participants and its funding. And it must be of real common European interest, and it must be very important quantitatively and qualitatively. And this was actually the background for our planning of the Fehmarn Belt case. It is, in brief, a coast-to-coast permanent infrastructure, a 19-kilometer tunnel between Denmark and Germany with a double-track railway and a 4-lane motorway. And it was established as a consortium, the Fehmarn AS, a state-owned limited company, and the state established guarantees for the loans to the tunnel, to finance the tunnel on the financial market, and also the state did some capital injections. Alternatively, it could be direct state loans or financing based on the Danish state budgets. But we think it was more interesting to provide them with state guarantees and some capital injections. And then it was decided that the loans or the financing should be paid back by fees or toll collection and railway charges. So we established this specific financial structure. But then we realized that there was a ferry company that was operating a ferry route over the same belt at that time, and they are still doing that. It's the Scanline Ferry Company. We notified this case as aid to the Commission in 2009 and got it approved. And then there was complaint by the Scanline's Ferry Company, and the Commission then took a no objections decision in 2015, and again the ferry company complained, and the European Court annulled the decision in 2018, and there was an opening of formal investigation. Formal investigation procedure the 5th of July 2019, and there was a formal decision by the Commission, and finally the Danish government brought the case before the courts in June 2020, and the court procedure is foreseen in 2022. It's interesting to know that in the Commission decision of 2015, the planning, construction, and operation of the road and rail in the hinterland did not involve state aid, and it was stated by the Commission that even if the planning, construction, and operation of the fixed link should involve state aid, it was compatible to the treaty Article 107(3)(b). This was rejected by the court in Luxembourg in December 2018, and the Commission took a new decision in March 2020. And the Commission decision was then that the depreciation of assets, fiscal loss carried forward, the joint taxation regime and the railway fees, and the use of the state property, the seabed in the Fehmarn Belt, and the state guarantees for the derivatives did not constitute state aid, but the measures consisting of capital injections and a combination of state loans and state guarantees was at least partly put into effect, constituted state aid. But then we have to give some concessions to the Commission and modify part of the financial structure. We modified the capital injections and also the loans and guarantees, as there in 2015 were no specific limits for these. And also we have to accept that the financing should be terminated and repaid after 16 years. In 2015, we had an agreement on 55 years, which is much longer, I must say. And also we have to raise the guarantee from 0.15% to 2%. But then we had the aid declared compatible with the internal market, and we should actually go on with the project. But the Danish government and administration didn't really agree to the assessment of the Commission. We think that the planning, construction, operation of the fixed links are not economic activities, but an exercise of public authority, public power, and the economic effects that are produced on the market and in EU are not a distortion of competition. We believe that the Fehmarn does not carry out an economic activity before it starts operation and is not offering any services on the market yet. And also that the collection of user fees, the toll collection, does not make the fixed link an economic activity, as the collection is linked to the activities of the public authority and maintaining a state-owned general road and rail infrastructure. So the user fees are meant to balance the public budget, not to get a revenue from running the fixed link. And then we have the opinion that if the fixed link involves state aid, it should be clarified from when, at least from the tunnel is operational. And also, we don't think there's no direct competition with the ferries, like a railway infrastructure is not in competition with roads, buses, or airports. So we could also have chosen to direct finance the connection by the state budget as a public important project of common European interest, and then the project would have been even more distortional to the ferry boat. So this is actually why we brought the case to the court in Luxembourg. I've here listed up all the arguments we have used for the case here. It's the same as the arguments I just mentioned. And we are, of course, looking very much forward to the proceedings in Luxembourg the 8th of November, as I think the Commission is also looking forward to. So here we have the clarification. Then the IPCEI hydrogen project. It was a project that was launched by the Commission in July 2020, and there was the establishment of this European Clean Hydrogen Alliance. And it was a framework of public and private parties cooperating and exchanging knowledge concerning the promotion of a European market for sustainable hydrogen through investments, and also to consider regulatory obstacles and barriers for this effort. The Commission was also very much involved, and it ended up with 22 EU member states and Norway signed a manifesto to go on with the project to paving the way for a cleaner hydrogen value chain, and committed themselves to initiate this IPCEI hydrogen project. And this was in 2020. And they stated clearly that this was their common objective, as it's stated here. Then it's important to look into the criteria and definitions of the IPCEI as they are stated in the Commission's communication from 2021, because it's a quite complicated document with a lot of criteria for these projects. And I've listed them up here. The project must be concrete, clear, and identical, and contribute to the objectives and strategies of the EU, and have significant impact on sustainable growth. It should also contribute to the Green Deal, the digital strategy, and the new industrial strategy for EU that has been adopted, and overcome obstacles and failures on the market or systemic barriers hindering the project's realization, and at least involve 4 member states and have a concrete positive impact on a larger part of EU. And it should give access to all EU and US member states to participate, and a lot of specific beneficiaries should be more than involved in the project, and it should have a broader impact on the economic objectives and strategies of the EU. It should involve significant co-financing from beneficiaries, and it should be proved that no significant impact as damage to the climate or the environment. Of course, it should involve the Commission, but also the European Investment Bank and the European Investment Fund. And then, of course, the selection administration of the project should involve the Commission, and the project should involve essential cooperation with partners, and undertakings should be large companies and undertakings, SMEs and startups in different parts of the European Union, and in particular in less developed regions. There should be co-financing from an EU fund, a substantial contribution from independent private investors, and the projects should tackle a clearly defined strategic barrier, have essential innovative impacts and value added, and also if it involves a first industrial deployment, it must make it possible to develop a new product or service with high content of research, development and innovation that make upscaling to test or serial production possible. So a lot of criteria have to be fulfilled in this process, and I think this is maybe why it took up to 2 years to prepare and get this project adopted. So we have really to prove that we can fulfill these heavy criteria and all these conditionalities concerning proportionality, necessity, transparency, prevention of distortion of competition, and quite comprehensive requirements on notification, reporting, and evaluation. But lastly, after 2 years, we succeeded to have the first project adopted, the HY2 Czech, the 15th of July 2022. And as Peter said in his introduction, it's a very large-scale project involving state aid on 5.4 billion euros, and also it is unlocking up to 8.8 billion euros of private investment, and involving 15 member states and a lot of undertakings, 35 undertakings in these member states, and a lot of research and development institutions, and as stated here, more than 300 other parties. And it also has been the Commission has also adopted an approval of the next hydrogen project, which is also very important, which is involving, I think, 11 member states and 38 undertakings, and also have a very huge state aid part on 5.2 billion euros and up to 7 billion euros of private investments. And what is our experience by being part of this process? It's been a very inspiring and mutually stimulating European cooperation. And we have very high expectations for new kind of fuels and new kind of energy in the European Union, also in Denmark, of course. But it has also been a very demanding cooperation, and also the process has been quite long. There's been much work done. It has been a multi-level process with many meetings between different parts of the system. And in Denmark, it started up with 25 Danish undertakings as interested parties, and it ended up with actually 2 undertakings took part in the final project. And it is a very important project for the Danish government, as I believe it is for the Czech government, and we have actually allocated 115 million euros to the 2 projects. And the IPCAR requirements, as I said before, involves a lot of criteria and documentation. So the advantages is that you can start up projects with a high volume, also high aid volume, and there's a lot of possibilities for synergy. but there also are some disadvantages. It takes a lot of time and cost to start up such a project. As I said, it took almost 2 years to make it up and running and to get it approved by the Commission. And also the requirements are very demanding. And also there's been a lot of work to coordinate between undertakings, beneficiaries, and public administrations. And for us, it has really been difficult to define and agree with the Commission on what is really the content of the first industrial deployment, the scale-up phase, and when do you see that this project is ready for commercial use. But finally, we got an agreement. So there's a lot of opportunity for sharing of knowledge, but the question is, will we really see a sharing of knowledge and a real cooperation on the pan-European scale, or will we just see that we have a common chapeau and a lot of individual small projects? Will we really see that the undertaking is willing to share part, at least, of the business secrets? It's a project that is being started up and has a lot of potential, but the coming years will show how far we can get. Thank you.
Thank you, Preben. I have 2 comments on your presentation. Firstly, we attach, now I speak on behalf of the Czech Ministry of Industry and Trade, a high attention to the hydrogen projects. So we are lucky that one of our Czech subjects is being involved in this IPCEI project. So that's the first comment. The second one, when I have seen the long administrative procedure for the adoption of the decision on the construction of the tunnel under Denmark and Germany that took 10 years, it remembers me well our Czech administrative procedure for issuing the permission on construction, railway and highway, which usually take about 10 years too. So at least we have come not only the hydrogen project, but the long administrative procedures as well, as I can see. So just comment. Now I will give floor to Mr. Karl Soukup, who can just reply on the question and issues being raised by Preben. Some of them in the summing up slide we can share, because even our colleagues from the Ministry of Industry and Trade share a lot of these comments. So floor is yours, Karl.
Thank you. Well, thank you, and thanks also for the organizers of the competition day to put also a stated topic on the agenda. I know it's not always at the core of the functions of a lot of national competition authorities, but still at European scale it's part of our competition law, so I think it's also good to have it as part of the competition day. I think it's also very important to talk about IPCIs, and you can of course talk about IPCIs, you can talk about IPCEIs, you can talk about IPCs, you can talk about IPCIs, IPCIs. I heard everything already in the last few years, depending on where you are located, and I think also in a surprising move of regulatory restraint, we have, at least until now, refrained from trying to harmonize the pronunciation, so it's still diversity. You can use whatever you want in terms of pronouncing it. Caroline and Preben have already said a lot, so I think I can be relatively short. I will try to repeat as little as possible from what was already said, because I don't want to give any incentives for the remaining audience to leave as well. When we talk about IPCIs, it has been, I would say, a sleeping beauty in the treaty. You have already heard that it was actually there since the treaty existed, so since 1957, but it was very rarely used until about 10 years ago, when we thought we need to fill it a bit with life. And the idea was to create this communication IPCIs to explain to member states how we see the potential use of this treaty clause, because if it's there, it should also be possible to use it. From the beginning, it was clear that we wanted it to be targeted at very big projects. So it should be big projects, not only projects important to one member state for one industry, etc., but it should be something which has a clear link to big European priorities, to big European policies and objectives, and should benefit the European Union overall. This can be, and you have heard this already, either single cross-border infrastructure projects of a particular size, or, and I think this has become more and more the use, integrated projects with a high innovative element. It's clear that these projects need to be linked to policies of the European Union, and I think when we look at the recent integrated projects, we heard already about microelectronics, batteries, and hydrogen, that these are clearly linked to policies ongoing at European level. So contribution to European strategy for key enabling technologies, the digital agenda for microelectronics and also for the forthcoming one. Of course, batteries and hydrogen very much linked to the Green Deal objectives, turning Europe into a climate neutral continent. We had a strategic action plan on batteries. We have EU hydrogen strategy. So there's a lot of policies which are focusing on these areas and where these IPCIs fit in very neatly. But it's also important to stress that IPCIs are not a miracle solution for all the problems we are facing. A lot of challenges can better be tackled with other means. Regulation, we have in a number of industrial policy areas, we have alliances, so you can do a lot. IPCIs can be part of the, yes, industrial policy toolbox of Europe, but it's only part of the toolbox. It's not the main instrument, and it doesn't fit each and every situation. Why would member states at all want to engage in IPCIs? Well, IPCIs provide for some flexibility which doesn't exist under other stated rules. In particular, when you compare to the aid which is possible under the research, development and innovation aid framework, well, this stops at a certain time of the development, and when we come closer to putting products on the market, and there the IPCIs still allow aid for what is called the first industrial deployment, so the upscaling from prototype to real to the size of mass production just before the entering into actual mass production. And the second important element is that, you know, in most areas of state aid we work with aid intensities, so you have a certain investment and you can get a certain percentage of this in terms of support. Here we work with funding gap. So we look at the costs of the project, investment costs and the first phase of operation up to the first industrial deployment. From this are the revenues deducted, and the difference is the funding gap, and this funding gap can be filled 100% with state aid in order to make the project happen. And finally, for the companies, what is important is that IPCIs allow them to become part of an ecosystem, of a European ecosystem in the area, in the batteries or in hydrogen, to find partners, to find others which might have interesting projects linking with their project, downstream or upstream. So to create really a European ecosystem for these industries. And this is also why this additional flexibility in terms of aid amounts, in terms of what part of the innovation can be supported, can be allowed, because it is industrial policy lifted to the European level. So it's not industrial policy carried out at national level, but lifted to the European level, which allows then also a more flexible treatment. But if this more flexible treatment is therefore a European industrial policy, then of course it also needs to be ensured that all member states and all companies have the opportunity to participate. That's why for us openness is hugely important, so that all member states can participate. And you have seen from the examples quoted before that the first IPCI, and I leave now aside Fehmarnbelt, which was an infrastructure project, so the first microelectronics IPCI was still with 4 member states only, and it was the big member states at that time. And we have reached now a situation where in fact the majority of member states is normally participating in an individual IPCI. So it's much more open, it's much more inclusive. We always also pushing member states to run open calls for interest, so that also all companies in the respective member states can really participate in an IPCI. And this openness and this wide reach is then also, I think, one of the safeguards against distortions of competition, because each and every company can itself also benefit from the support tools available there. I was asked to talk also about the revision in 2021, and I think there's one slide on this. As already said, I think the communication from 2014 did not need a big review, so it was also, let's say, a small review, not a big overhaul. Also, there was rather limited experience with the communication in 2021. But there were a number of areas where we still tried to improve it. This is, for example, what I mentioned already, the openness and inclusiveness. So in the previous communication, it was said that it should be at least more than 1 member state. Now we said at least more than 4 member states. So to make it from the beginning clear that we want a majority of member states to participate in the IPCIs. What I said already, the running of open calls for interest. Then we also try to facilitate the participation of SMEs. Preben said that it's a difficult process to run an IPCI and to be part of an IPCI. This is true. That's also why I think it is sometimes a bit difficult for SMEs to participate, and there we try to get a more proportionate assessment of the smaller companies and the smaller projects into the communication. Then, of course, we updated the list of EU priorities and policies in the communication, because in 2021 we then had already the Green Deal, the digital agenda, the open strategic autonomy, and all these things which were now also integrated in the communication. And we tried to give more guidance on the compatibility assessment, like, for example, the notion of first industrial deployment, etc., so to make it easier and more predictable for member states how the assessment would look like. So IPCIs is a great tool, it's a great possibility, but for sure it's not a free lunch, and I think this was also already clear from what we heard before. It's not a free lunch because it requires first member states to cooperate. And we have learned in the past that this is not so obvious. For member states to talk to each other, for member states to align priorities, for member states to align also timelines, being it for project planning, being it for budgetary purposes. It requires companies to talk to each other, of course, while fully respecting antitrust rules. It cannot be that with stated rules we would advocate anything which would run foul of our antitrust rules. So it's clear that all antitrust rules need to be respected while cooperating. But it is really cooperation, member states and companies. Important in the IPCI is that member states are in the driving seat. It's not the European Commission which is putting together the IPCIs. It's not us saying an IPCI in this area needs to be done, and these are the member states participating and these are the companies participating. No, it's a bottom-up approach. Member states need to decide whether they want to jointly run an IPCI, and if so, they also need to invest into this. It is no free lunch because we would expect companies to create big spillovers. And big spillovers means that they should not only themselves profit from their project, but of course by cooperating with others there's already some spillovers, but we would also expect companies to share the knowledge created by research and development projects. For example, by attending conferences, by dispersing information, to the extent that it's IP protected, to also grant licenses to this. And we had, for example, in the first microelectronics IPCI also situations where we pushed big foundries, so chip manufacturing capacities, to open their labs, to open their production facilities to SMEs, to startups, to test their ideas there. So we really try, and it's difficult to be more specific because it's always tailor-made to each IPCI, but we really try to push these spillovers so that the effects of the IPCI go beyond the participating member states and the participating companies. Finally, it's not a free lunch because we look very careful at everything we receive. I mean, this is what competition authorities are supposed to do. So we check carefully all the aspects, for example, the innovativeness, which normally we don't do ourselves, but with colleagues from other departments of the Commission who are, let's say, perhaps better equipped to do this assessment, like our colleagues from the Joint Research Center. But we look very carefully at competition distortions. We look very carefully at the funding gap analysis to see whether the company really needs the money it is claiming it needs to support to carry out the project. And their experience shows from the last few IPCIs that normally the finally approved amounts are some 30 to 40% lower than what companies originally claimed they need to carry out the projects, and the projects still happen. Of course, reducing the funding gap is not our objective as such, but I think it is not so bad side effect of our work, because at the end, each euro of taxpayers' money saved can be put to another use. Finally, we also expect member states to be active and to screen and scrutinize very carefully the projects before submitting them to us. It's not that member states are a post box where company projects are simply passed on. Member states need to do their part of the work, and they need to subscribe to that what they are putting forward as projects is finding their full support and has been checked carefully by them. I think we heard about the complexity of the processes and that all this takes a long time. This is true. I think it's fair to say that the first microelectronics IPCI was a big learning experience for member states and the Commission. That's also why it took quite some time. But in the meantime, I think we have gained experience also on the member states side. The authorities have gained experience, and the two last hydrogen IPCIs took less than 1 year from pre-notification to approval by the Commission, which I think, given the number of member states and the number of companies and the amounts involved, is not such a bad track record. Let me just add two final points. The first is, we heard it's not so easy to get aid approved under the IPCI. My plea to member states and companies: there are a lot of stated possibilities outside IPCI. And projects can also be approved under other set of rules which might fit better to a specific project. We have the General Block Exemption Regulation, the GBA, under which member states themselves, without even the need to come to us, can grant amounts up to a certain amount, aid up to a certain amount. We have now the CEAC, the Climate, Environmental Protection and Energy Aid Guidelines, in force new since beginning of this year. We have the research framework. So there are a lot of possibilities for companies to receive aid without the need to go through the IPCI experience. And still these companies can be part of the ecosystem. I think we call these companies then indirect partners, which are part of the matchmaking, which are part of the cooperation, but then aid is not granted based on the IPCI decision, but is granted based on other rules which might fit better for this specific project. Last thing, an outlook. We have a number of IPCIs currently pending. We have the third hydrogen IPCI pre-notified, which is focused on infrastructure, so pipelines and similar. There is a fourth one which is about to be pre-notified, which is focusing on mobility solutions linked to hydrogen. We have a second microelectronics IPCI pre-notified. It's called Microelectronics and Connectivity. I think also showing that it goes beyond chips as such. We have also one in the pipeline on cloud computing and cloud infrastructure and services. Microelectronics too is very big, more than 100 companies pre-notified, so it's a very complex exercise also for us. There are also projects in the pipeline regarding health, so research in the area of health and pharmaceuticals, which is currently in the making. And finally, we know that there are, let's say, in the very first steps also ideas of some member states to establish an IPCI potentially in the area of solar and photovoltaic, but this is, I think, still in the infancy. So IPCIs are there to stay, I would say. I think they are a great tool. They are to be used with caution, but there are situations where they really make sense, and I'm confident that they are contributing to bring Europe forward in these essential value chains. Thank you.
I would have one question on you, Karl. Having experiences from several IPCI projects, how is being assured in the project that the companies will really, at the end, share the new knowledge, the new technical, let's say, documentation, or I don't know, the results of the IPCI? Because from the logical point of view, each company, even if it receives certain amount of state aid, is trying to, of course, to save and to keep it every internal development as a commercial secrecy usually. So are there any special assurances in the IPCI projects for these reasons? Or?
Yeah, I mean, first, of course, what is notified to us and becomes part of our compatibility assessment also becomes then binding on the companies and the member states involved, because, of course, if you notify a project and then you don't carry it out as notified, then in fact you are misapplying the decision. And then there is, in each IPCI there is a governance structure put in place by member states. So there's a structure which goes beyond the approval by the Commission, which is then regularly meeting, where there are exchanges about the implementation of the projects. So there's a follow-up of this, and as part of this, of course, also compliance with the promised spillover measures is watched. Governance is very much driven by member states. The Commission is normally there as observer, because we are still watching this more from the outside, of course, because we cannot be player and arbiter at the same time. But there's a governance also going forward, and the verification of the results of the IPCI, which I think will also be very interesting in a few years' time to see whether the IPCIs have really achieved what they were supposed to achieve. So I think there's also great opportunity for academics then to look into this.
Yeah, I also have a question, maybe to what extent do we involve also non-EU players in these things? Because as we look into independencies versus developing our own capabilities, in some strategic value chains, it will be impossible to play a leading role in the entire value chain. So to what extent do we say, okay, if we can't do everything, do we want to have a certain position somewhere in the supply chain where we are strong, where we are the main element, and how does this then fit in the projects of common interest and involving non-EU players? Because in some value chains we can't go without, maybe.
No, I think that's why I was stressing that IPCIs are part of the toolbox, but they cannot solve all the issues. Of course, we cannot solve our strategic dependencies on raw materials via IPCIs. No, I mean, if certain materials we simply don't have, an IPCI will not help. I think also for opening a mine, an IPCI will not help. I think you have different problems than funding if you want to open a mine in Europe. So it is, for certain elements, it can be a very useful tool, but there's a lot which needs to happen outside IPCIs. We have alliances, we have regulatory tools, I think we are not using regulatory tools probably sufficiently. There's trade policy, etc. So there's a lot of elements which I think need to play together to achieve these objectives, and IPCIs can partly and sometimes contribute, but certainly not for all problems. I think we need a certain degree of modesty also on this.
Okay, so thank you for your answer. So we did a little bit PR for the IPCI instrument, which is the new tool, as you mentioned, and it has supplementary function to the classical block exemption regulations or another guidelines that's being used by the Commission for issuing the state aid in individual areas. So I would like to express my thanks to all panelists. I don't know whether we have some questions.
Actually, it seems that you explained it so well that there are no questions from the audience, but probably I would be so bold and ask for myself, even though I'm not sure if it is really a question for you, but as I was listening it the whole day, I just came up to a question in my head, like, isn't it contradictory what we do? We kind of regulate the companies and the competition so strictly, and then we try to motivate them to cooperate. So first we regulate them in cooperating, and second we encourage them to cooperate, which must be very difficult for the business side to understand. How difficult it is then for the authorities to be the one to decide where it is still okay, what we want, and where we are behind what we want, when we passed the line.
No, I think it can be challenging, yes. But I think what we have seen is, I think it's less an issue for big companies. They know what they want, they know where they want to go, they also know with whom they might want to work together, and also under which conditions they can and what they cannot do. But what we have seen is also that in particular for smaller companies and startups and SMEs, it's not that obvious. And then I think that they profit very much from the matchmaking events. So there are events where all potential players, companies are coming together so that they can discover who else might have an interesting project which perhaps fit together, where there are complementarities, etc. Because they don't have this overview of the market and the sector to see and to know what others are doing. So I think it's mainly for the smaller players that this is important.
And just maybe to supplement, of course, the competition rules have to be kept even during application of the IPCEI. Of course, it's specific case, IPCI, when you create something like a consortium or something like this. So of course, it's a specific case, but otherwise, as we mentioned, it's being used just in the areas where the EU up to now have had certain gaps, like the microelectronics, batteries, chips, fifth generation networks. So usually hydrogen, as was mentioned as last example. So usually we use this tool for the areas where the competition itself hasn't helped yet. So I mean, without any incentives, subsidies in the hydrogen technology, probably competition itself wouldn't solve the problem or wouldn't develop the hydrogen technology, at least at this phase.
Thank you. So, if there is no question, I would thank to all of our last panelists, Petr Solský, Caroline Batz, Karl Soukup, and Preben Peterson. Thank you very much. You may go and take your seat, because we'll go to the final point, which will be the conclusion. So, this was the last panel of this European Competition Day, but we should still sum up what we've heard. So I asked the chairman of the Czech Competition Authority, Petr Mlsna, to help me with that. We had 3 panels: new challenges to competition enforcement in a much more online and greener world, the principle nebis in idem, and now projects of common European interest, and how it contributes to the strategic objectives of the EU. So let's start with the first one. To what extent do you think competition authorities should be vehicles of change or vehicles for sustainability within the Green Deal strategy, and which specific actions can they take in this regard?
I stated clearly in my opinion remarks that the competition authorities are primarily here for protect the competition. So therefore their role within the Green Deal and ultimately their ability to enforce this policy is very, very limited. And I take the view that other authorities, such as the Ministry of the Environment, are primarily designed for this purpose. So the role of the competition authorities should be more punitive. Agreements or actions of undertakings which hinder sustainable progress for their own benefit must be severely punished by competition authorities. On the other hand, we can consider being more willing to provide possible comfort letters where a transparent agreement clearly translated into sustainable benefits outweighing potential detriments from distorted competition. That's my opinion.
We've heard about many tools that could be used for competition protection and investigation. With that regard, do you, from your practical experience, would you choose some of them? Which one would you prefer?
I know that some states in the European Union have legislatively and judicially authorized the use of wiretypes. So in the future, I would welcome the possibility of having this tool in our portfolio and portfolio of the Czech Competition Authority, because we have a significant number of cases where there is evidence of a cartel in this form, but currently legislative setting in the Czech Republic prevents us from applying it.
Yeah, we've heard about but maybe a bit more in detail. Let's move to the second panel, the principle nebis in idem. Not an easy one. Has there been any changes to perception of this principle?
This panel was more about the legal philosophy and the constitutional and international law, but also the B-Post judgment has changed the criteria for assessing what falls under the principle nebis in idem in competition cases. This change should not have a factual impact on competition cases of this type. Thus, in competition cases, it will still be possible to investigate the same infringement in parallel in several jurisdictions. But it is quite difficult to discuss it, and we know it all.
Yeah, and we had a practical example here. Let's move to the last panel. We heard many examples of the project of common interest, and we've seen how important it is to cooperate over the borders and cross-sectoral. But we also heard only about one project where the Czech Republic is present. Why so? Where's the problem? Shouldn't the authorities that are in charge of that be more active from our side?
That's right. That's right. We have information about further activities of Czech companies which intend to participate in these projects, mainly in microchip or on cloud. We closely cooperate with the Ministry of Trade and Industry in preparatory work of this future project, and I believe that we will succeed. And we also cooperate with the Commission in assessing this project in terms of state aid rules. But generally, the Czech entities should be more active in preparation of future IPC projects, and it is important because it is an important tool in strategic areas such as automotive, electro batteries, microelectronics.
Yeah, would be nice to be part of some more projects, definitely. Is there something else that you would like to say? I think we are just getting to the end of the competition, European Competition Day in Prague.
Yes, I would like, ladies and gentlemen, dear colleagues, I would like to thank you all for attending at the European Competition Day. I really appreciate your presence here in Prague, and greetings also to everyone who watched the conference via live stream. Today we have discussed the ongoing economic crisis, and I hope that our deliberation, presentation and discussions will contribute to an effective competition policy which help the European Union overcome the crisis very soon. Ladies and gentlemen, dear colleagues, the European Competition Day is over. Thank you for your attention and goodbye.
Petr Mosna, Chairman of the Czech Competition Authority, closed up the European Competition Day. I hope it brought new ideas for you and that you enjoyed it. And I wish you to enjoy the rest of your time in Prague. And just for those who would be interested about the special symbol of this graffiti on this wall, it's the third big window. And top left corner, when you look from outside, you won't see anything from here, but when you get outside, you'll see it there. So I wish you a wonderful rest of the day and good luck with everything.
Good.